bill that's coming, and we are thankful that, as Reverend Mahoney
All right, good morning,
said,
everybody.
Roe
We are
versus
live
Wade is
outside
being
the steps
dismantled.
of
It
the
is
Supreme
being
Court here
dismantled
in
this
Washington,
court.
D.C.,
It is being
awaiting
dismantled
comments
inside the
from
abortion
Ken
clinic
Paxton,
as
Angela
workers
Paxton, and
leave,
others
and it is being
in regards to
dismantled in
the
the heart
hearing and the
of
discussion
Americans
on
as
the
we
Texas
realize
Heartbeat
that
Act
abortion
that is in
is
front
not
of the
fair
Supreme
for
Court
women, and
right
women
now. That
deserve better than
discussion
abortion.
started
Thank
at
you.
10 a.m. here local time. We've got a few speakers out here before they get to those remarks. These are pro-life organizations, but we're glad you're with us on this very historic day here in Washington, D.C., as this is the first time that the topic of abortion has been brought in front of the Supreme Court in a long time, and also especially now that Trump has had a few appointees to the Supreme Court, so has a conservative edge of 6-3 on that. So as you could tell by the hashtag on the mantle there, the hashtag Dismantle Roe, this could be the beginning of undoing Roe versus Wade's, of course, a very historical decision in American policy making. But we're glad you're here joining us here today. We encourage you to share this broadcast. We are witnessing history today, as these speakers have laid out there. I won't get to these speakers here in just a second, but they have really laid out the groundwork to reversing Roe versus Wade, and this would be right now. But first, we want to make sure we all support a patriot like Mike Lindell over at MyPillow.com. I know we have talked about him being a patriot as far as the election integrity goes, but he has also been such a pro-life advocate. And especially on a day like today, if it's in your heart to support the pro-life movement, if it's in your heart to support Mike Lindell and over at MyPillow.com, I just encourage you right now to go to his website, MyPillow.com, MyStore.com, and shop and support him that way. This is the way we can get around all of this cancel culture, is to support people and organizations financially. And now more than ever, it means more. We're on the steps of the Supreme Court. He's said many times that he'll be at the steps of the Supreme Court with the election integrity, that he has really paved the way for election integrity discussion. So I just want to encourage everybody right now to go to MyPillow.com, MyPillow.com, put that promo code RSBN at checkout, and you'll get up to 66% off your entire order. Now's the time to get a hold of the Christmas. We got Christmas coming. We got shopping, holiday rush coming up, a lot of supply chain shortages where all these products are right there, ready for you to buy them. Liz Willis and myself was just at the My Pillow factory just a few days ago, and we saw them. They're cranking out thousands of products every single day. So we just encourage you right now, if it's in your heart on this very special day for pro-life here in Washington, support Mike Lindell, who's also a big pro-life advocate and is really pushing to protect the rights of the unborn. So I just encourage you right now to go visit MyPillow.com, MyPillow.com, and check it out. And MyPillow.com, MyStore.com, put that promo code RSBN at checkout. But we're glad you're here. We've got a few speakers lined up. I will say I've been told at 10:50, 11 o'clock, Attorney General Ken Paxton of Texas, who actually pretty much has backed this bill and has brought this to the Supreme Court, will be here. Angela Paxton will be here as well, and they're going to talk about it. And this whole thing kicked off in front of prayer. It started with prayer. It started with prayer. And I will say that just to the left of us right now is a pro-choice rally. Let's see if we can show that over there right now. It's a very different scene. On the pro-life side, it's guided in prayer. It's been a prayer and worship pretty much the entire time. But when you cut away to the pro-choice, a lot of yelling, a lot of scream, a lot of anger, it seems like, from that side. Now, that rally has pretty much subsided up until this point. I don't know what they have planned to go moving forward, but sizable crowd here, good amount of media is here, as you would expect. This is really the first time we've seen the discussion of abortion on the docket here at the Supreme Court, especially following the great leaders in the state of Texas, the conservative movement, that have put that on the docket here to be reviewed today. That kicked off at 10 o'clock. It kicked off with prayer here. And if you're not familiar with the Texas Heartbeat Act, it simply prohibits any abortion taking place after 6 weeks of detection of pregnancy. That is when the science, that is when the medical community has determined when an actual heartbeat exists in the woman's womb at that point. So this has been a very historic decision in the state of Texas, and it could really impact the entire country. Now, if you look back, there's also another. Mississippi has a 15-week ban on abortion as well. I was told that that's going to make its way here, possibly to the Supreme Court here shortly. So this is a topic that not only will dominate the 2022 primary season, but it will also go well into the presidential election of 2024. Of course, you've got the dominant topics of the border, national security, the economy, but the right to life, the pro-choice movement is up there and very high in the categories of what is concerning to many Americans. And of course, right here in the Commonwealth of Virginia, big election tomorrow night between Glenn Youngkin and Terry McAuliffe. Those names have been tossed around here at this rally, as well as Glenn Youngkin, start conservative, very much pro-life, and Terry McAuliffe, the exact opposite, very much pro-choice. So that has even made its way into the political realm here in a gubernatorial race that takes place tomorrow. But just a historical day here in Washington, D.C. We're so glad that you're joining us, and we want you to make sure that you spread this broadcast as much as possible. Right now, we are streaming live on YouTube, Facebook, Rumble, and also via our app. I just really encourage you right now to go download our app. You can get that at the Apple or Android store. Download that to your phone. It's absolutely free, and that's one way that you can stay in touch of what we have going on right now. With all these broadcasts, not just Trump related, but anything that's political, anything that affects our lives. And this will affect all of our lives, this decision that could be potentially reversed down the road. It affects a lot of people. So I'd encourage you right now to download our app on your iPhone, your Android, have it in the palm of your hands. We have great shows on there that you can stream us from anywhere. Also, share and like us on Facebook, Instagram, Twitter, all of our platforms, Right Side Broadcasting. You'll see it on there. It's important that we're able to utilize social media as much as possible right now. Let's magnify the voices and the messages here today. Let's make sure that we spread the good news of the gospel and the good news of Jesus Christ. And what we're trying to do here from a biblical framework in our country is so important, that we stay focused on what God wants, not what we want, but what God wants. And that is evident with the songs of worship behind us about the right and the sanctity and the value of the unborn life. So we're glad that you're joining us here today. And we encourage you to pray for all of us here today. Pray for the media. Pray for the outlets here. Pray for Ken Paxton, Angela Paxton, and others that will be coming on stage here. Pray for the ones here that are against us. Pray for our enemies here. Pray for the ones that are pro-choice. Pray for the ones that one day they might wake up and their eyes might be awakened to what is really in their heart for what they should do. So pray for everyone here today. Pray for Right Side that we're here. Pray for the media that is here, and that hopefully it is covered in a very fair and non-biased way as far as the coverage here of the Supreme Court. Because if you look around, it's a very peaceful movement right now. It's peaceful on both sides. I would say one side is more vocal than the other, but as far as the pro-life side, it's been very, very peaceful at this point. Sizable crowd. If you're just not joining us, welcome. We are live in front of the Supreme Court here in Washington, D.C., awaiting remarks from Texas Attorney Ken Paxton. Will deliver a few remarks in regards to the discussion that's going on behind me discussion on the Texas Heartbeat Act started at 10 o'clock here local time. I was told that it would take about an hour for those remarks to conclude. Once that happens, you're going to have several speakers behind me come out and give their remarks to what they heard there in the Supreme Court. Now, if you're looking for a stream for the Supreme Court as far as the audio or the video, that is not happening. That is something that is not available to anyone at this point. I believe there is perhaps some audio that you can get from the Supreme Court, but I don't know where that link would be. But we're going to have all the details that you need to know right here, because as soon as this thing wraps up behind us, they're going to come out and tell us exactly what they heard and perhaps how they move forward with this pro-life effort that we have in this country. And I'll step aside. If you're just now joining us, we've got a praise and worship going on, which is very, hey, it feels good to see that going on right now. You see this a lot. We'll say this when we go cover rallies and a lot from the conservative side. You do see a lot of prayer and praise and worship, which is I think one of the things that really that grounds us in our faith and our biblical principles is faith. So it's a big important part of all of this.
God, we just ask, we collectively pray.
Let's see, let's listen in on this prayer real quick.
Not because we're anything great. It's only through the Savior on the cross that actually forgives us and helps us all to be clean and one. We're all sinners. So, Father, we ask that you would just help them to see that they would come to you for that healing of that brokenness. In Jesus' name. Amen.
All right, pause for a quick prayer there, but we're glad you're joining us.
We want to keep announcing about schedule.
Let's listen to the schedule real quick. I'll get you up to date.
Going on right now. The Texas Attorney General and his team will come out of the court when the case is done. They will speak to the press, and we would encourage everyone in the pro-life community to stay, to support the Attorney General. It was truly groundbreaking. Weren't you amazed a month or two ago when you heard about the case that abortions were being banned after 6 weeks? And the fact that the Supreme Court refused to issue a stay against it. So we really want everyone to stay and remain. We also want to continue in an attitude of prayer. We gathered early this morning and have been praying. We're so thankful for the different groups that have come, that have prayed. I also want to, having been in this movement so long, abortion is a very passionate issue. We are living in a culture right now that is on the high burner in terms of issues. Right next to us, we had pro-choice people here. No acts of violence. Everyone had a chance to articulate their views. Everyone had a chance to share their views. And we think that that's the way to go. And what we do want to thank is the Supreme Court police who oversaw this. And if you want to give a hand for them, they did a great job ensuring that everything would run smoothly and clearly. And my aunt and my cousin used to say, I'm just filling time right now, by the way, but we'll pray in a minute. My cousin used to say, don't throw flowers at yourself. But having been at Supreme Court cases for 35 years, I made the recommendation to put the barricades here and to keep the groups separate. And I think that worked out really well today, don't you? That this is America. This is the most hallowed ground for free speech in the world, the public sidewalk in front of the United States Supreme Court. It's the only non-permitted sidewalk in our nation's capital. So we welcome vigorous, robust debate, even if we disagree with that, even if we struggle with that. But it needs to be done peacefully and prayerfully. Let's continue to pray. We still hear the arguments. I'm going to ask anyone who didn't get a chance to pray earlier if you want to come up. I want to do something else in just a minute. But if anyone feels to pray, let's continue. We are praying into history. We are praying for the Holy Spirit to shape and change history. We are praying for God to move. And this will be a turning point in our nation when we succeed on this case. Father, as we are hearing the arguments right now, we pray, Father, for every justice. We pray for all 9, particularly Chief Justice Roberts and Associate Justice Kavanaugh. We pray for the Attorney General of Texas. We pray for this truly innovative and creative way to end abortion violence in America. Guide them right now. Father, right now we are doing the most important thing we can, and that's prayer. We are doing the most critical thing we can, and that is crying out to you. Move in power, God. Touch lives.
If you're just now joining us, we are live at the steps of the Supreme Court. As he just said a few minutes ago, discussions are going on right now inside of the Supreme Court, reviewing, discussing, hearing arguments on the Texas Heartbeat Act that's going on right now. Of course, that was put into law, I guess about a month ago, it seems like, several weeks ago in the state of Texas. And could that be the catalyst to reverse Roe versus Wade? And we have as you can see, the hashtag proudly displayed on the microphone up there, the hashtag dismantle Roe. That could be the very beginning of something historical here in this country. So we're glad you're joining us. Ken Paxton, Angela Paxton, and other Texas representatives are scheduled to speak here immediately following the discussion inside. So we're going to have that here for you as well. We'll be live for that. And you're getting a good look at the media that is here. Now, we knew coming here there would be a sizable crowd here, not only for pro-choice and pro-life, but also from a media standpoint. This is a hot issue. And if you look at voters across the country, yes, the economy is up on one of the top of the list. Yes, the border security and immigration reform. But if you also look, Americans want pro-life. They want to protect the life of the unborn. That is something that many Americans will fight for. And we will see that going into the primaries. We'll see that going into the 2024 election, that this is an important topic. So today is a very historical moment. Now, today is the first time that we've seen abortion discussed at the Supreme Court level, and especially since Trump has appointed his Supreme Court justices, and now the conservatives have a 6-3 margin. What happens now? And so today could be the beginning of that reversal on Roe versus Wade. So we're going to see how that all plays out. And of course, the state of Mississippi also has an abortion law that is set to be on the books coming, I believe, in the next couple months, banning abortion at 15 weeks. Now, let me recap real quickly. The Texas Heartbeat Act prohibits any abortion after 6 weeks of pregnancy, and that has been the time that the medical community has detected when a heartbeat is detected. So that's hence the name Heartbeat Act. But it's been, I'm going to move my way over here as we get a good look of the size of the crowd here. We've got some people that have got their mouths taped with life. They've been engaged in prayer ever since we've walked up here. We've been here about 30 minutes now, and to kind of look around and get a good idea of who is here, what is it like, what's the scene like here, what's the mood. And this is it. It's prayer and worship on the pro-life side. It's a very spiritual guided. Like, when you look at the pro-life movement, it is grounded in faith. It is grounded in guidance of what God wants us to do. And it seems like on the pro-choice side, it's more of the my body, my choice type of narrative. Now, we have seen a little bit. I'm trying to exactly find out what that lady with the bullhorn is calling out, but you might see the sides mixed up a little bit. They said earlier they put a barricade up here, rightfully so. Two very heated topics, and that we certainly don't want to move over here. Just get out of the way of everybody. We've got two very heated discussions going on, and so those worlds kind of mix every once in a while. They've done a great job. Sometimes those worlds kind of mix in, but they've got a nice barrier here that really separates the two demonstrations. So the comments are set to start at around 11 o'clock. Now, as they said earlier, you know, the Supreme Court and all the discussions on this, well, it could be like a church service sometimes. It may not end at the scheduled time, so it could be a little after 11 o'clock before that takes place. But until then, we'll be out here. We'll see if we can talk to a few of these supporters. Let's see if I can I'll see if I can get a hold of somebody to talk on camera with me. But this is something that just affects every American and really doesn't have a social or kind of geographical type of standard. I mean, we've got Democrats out here that are pro-life. We've got all types of races pro-life. And I would say on the same time that would apply towards the pro-choice as well. So there is no standard, typical pro-life individual. They come from all walks of life, which makes this topic really interesting, how it does cross over, and the people that are grounded in their faith tend to be pro-life, and then ones that have no faith that are lost. You guys want to talk? Yeah, let's see if I got a nice pro-life supporter over here. First of all, glad you're out here. God bless you coming out here on a very historical day here at our nation's capital. What's your name? Where are you from? Why are you here?
My name is Julia. I work for Students for Life Action, and I'm from Florida. I'm in town in support of the Texas Heartbeat Bill.
So your thoughts on coming here today, seeing the overwhelming support that it's out here, really for both sides. This is an issue that a lot of Americans are very passionate about right now.
Absolutely. I think that it's a beautiful thing to disagree on. It's what's best for women. The pro-life stance is that abortion hurts women by saying that they must kill their child in order to meet goals in their life. And we're the side of hope and happiness and joy. As you can see, and I'm sure you witnessed, my colleague was sharing her experience of miscarrying her child, and she was told by a pro-choice woman, pro-abortion woman, good. That was her response. She said, good that you had a miscarriage, and not, I'm so sorry for your loss, or I'm sorry that even you had to experience that pain. And that's really what the pro-abortion side has had to bite down on, is that violence of abortion is a human right, and we don't believe that violence is a human right.
And I think it's very interesting how this all started with prayer inside the Supreme Court and outside here. I've said this before, people that are pro-life tend to be very grounded in their spirituality. Not saying that there's pro-choice people that aren't, but we're guided by what God wants us to do, not what we want us to do.
Yeah, and what's beautiful about working for a secular organization is I'm able to find common ground with people that don't otherwise have a relationship with Christ or with God. And I've noticed when they start to honor creation from all stages, that they start to honor a relationship with God on a different level. So it's a beautiful thing to say I work for a secular organization, because it opens that door, like, I will listen to you at the very least, and then we're able to individually change hearts and minds to the more loving side of history.
Yeah. What has the response been for you as you've walked around? There have been some pro-choice people here. Are they been vicious to you? Have you had any type of unkind words? Any bad experiences?
I am accustomed to the other side's anger towards our...
Why do you think there's so much anger? Because I noticed that when we first came up, they're praying here, but then it was megaphone after megaphone yelling over there. Why are they so angry?
Well, I always come back to that anger is a secondary emotion. And it's much easier to be angry than it is to be sad. So I think for them, it's a coping mechanism. And if they can lash out in anger, they don't have to have a heart-to-heart conversation with us. And so we really, all of our students that we work with in all 50 states are trained in de-escalation tactics. And that's so instrumental to changing hearts and minds on this issue.
That's great, because that is a very emotional issue. People do get charged up, and you know, we haven't seen that here today, and I'm hoping that we don't see that. I'm hoping it stays just like this, but as some of the remarks are brought out at 11 o'clock, you know, maybe we get a little bit more insight of what the Supreme Court's thinking.
Definitely. We have been here since the wee early mornings. We got up before the sunrise. We made our signs. All of our students came from all over, and we carpooled in here, and we're so excited to see the Supreme Court on the side of science, logic, reasoning, morality, everything that it means to be an American, and that means protecting humanity at all stages of development.
And it's interesting that, and this is just a side note, that whenever you hear people talk about my body, my choice, but they don't necessarily agree with that logic when it comes to getting the vaccine or anything like that. Like, you can't use that argument against them.
Yeah, I mean, it's definitely a pick and choose situation. I think what's really cool about being on the pro-life generation is you don't necessarily have to be Christian or Republican or anything. We have people here that are
Democrat earlier came out, Democrat for life. I mean,
amazing. Yeah.
I was high-fiving her basically when I heard of that.
Absolutely. It takes a very brave person to stand up to the abortion industry, and we will walk alongside you no matter who you are. Absolutely. And as you saw me, I got emotional earlier hearing my friend's story. I've been going to rallies like this since 7th grade, and I've never broken down. But when I heard my friend share about her miscarriage, I just broke down because I didn't know that. So I'm so grateful for everyone that is here sacrificing time and energy to stand up for the protection of the preborn.
Well, God bless. If you have anybody with your organization wants to come over and share a few words, please bring them over here.
I'll get you Hannah that shared about her miscarriage.
That would be great. So we appreciate that.
Brian.
Broadcasting, yeah.
My name spelled out.
Well, we're live right now, so which is nice. Normally we'd be able to do that, but we're live, so we appreciate you coming over here, and just keep praying. And all I know of our viewers are very supportive of what they're seeing right now. This is what it means to stand up. StudentsForLifeAction.org. Go check them out on the website and get involved. And social media for you guys as well?
Students for Life Action on Instagram, Facebook, Twitter. We appreciate any and all support that you can give to our very brave student activists. Thank you.
It takes a lot of bravery to come out here. And as she says, to stand up against the abortion industry, you got to be able to take some bullets. You got to be able to take some criticism, and that is one thing that you guys have been trained on, which I really like that. Maybe we need to train that for media journalists too.
We'll train you. We will train you in de-escalation tactics. Students for Life will train you for free. Promise.
I just count to 3 and take a deep breath and walk away. Is what I do.
Pray.
And pray. All right. Well, if you can get her round up, I would love to talk to her as well.
Have a good day. Thank you so much.
Thank you. And just one of the stories, because everyone has a story of why they're here. I'll share something personal with you right now. Today is my birthday, November 1st, 1969. That's when I was born. My mom gave me up for adoption. My biological mom gave me up for adoption. It was an unwanted pregnancy at the time. She made a sacrifice to go to a women's clinic, have me there, where I would be safe and comforted and taken care of. And then by God's blessing, I had adoption parents come and get me and adopt me at just a week or so old to give me a happy home. So I only say that to you is that I think it's God's plan that I'm here right now on the steps of the Supreme Court fighting for the unborn, fighting for the pro-life movement. There's a reason why I'm here. And my biological mom, wherever you're at, perhaps you're watching us right now, thank you for not being selfish in your ways, but honoring his ways and doing what's right and basically giving me a chance at life. And that's what we're trying to do here, is we're trying to give the unborn a chance to have life. The discussion is going inside right now, and I want to thank everyone in the state of Texas and Ken Paxton and Greg Abbott and all the ones that have come together for this Texas Heartbeat Act, and that could potentially reverse Roe versus Wade and give people like me, someone that came from an unwanted pregnancy, something that was at one point I would think that it was a decision whether or not to abort me or to have me. And I'm so blessed to be able standing here today on the side of pro-life. Thank you very much for that. I want to bring you in here. Brian Glenn with Right Side Broadcasting. How are you doing today?
Nice to meet you. My name's Hannah. I'm the Capital Area Regional Coordinator with Students for Life of America.
Wonderful. We were just talking to your colleague here about what it means to be here on this very historical day here in Washington, D.C. You've got your sign, you've got your stories. What brings you here?
So, I mean, obviously I'm here in support of the Texas Heartbeat Bill. My personal story, when I was in college, I had an unplanned pregnancy when I was 18 years old that, unfortunately, before I was able to even figure out what my thoughts were on the process, at about between 6 to 8 weeks, my child, I suffered a miscarriage and the loss of my child. So while I don't know what it's like to have an abortion, I do know what it's like to see that child at that early stage of development and to see the humanity and the worth of my child. And I want to give dignity to all of these children that are not given that dignity on a daily basis.
I can't tell you how special that is. I had just shared a story. I don't know if you heard that, but what it means to me to be here. We have got to fight for the unborn. We've got to fight, and we cannot use abortion as some type of birth control, and that people do irresponsibly to just eradicate life at will just because they don't want it.
Yeah, it's unfortunate that people just don't fully understand the issue of human rights and how people deserve a choice. You know, in the name of pro-choice, people say that women have the choice, but what about that child in the womb? What about their choice? What about their right to live and have a purpose? Just like God gives all of us a purpose, what about theirs?
That's why you're here. That's your purpose today.
That's my purpose here today.
Yeah. How can people, I know you're with the same Student for Life, okay, same organization, so go to the website right there, studentforlifeaction.org. Get involved. I know you guys probably have things that you go around the country, around D.C., and advocating for pro-life.
Yeah, we do things all over the country all the time. We're here at the Supreme Court very often. Anytime something is happening here, we are here. So if you just visit our website, you can find all kinds of ways to get involved. Really, whether you're in D.C. or whether you're anywhere else in the country, it's so important that we stand up for life and join together as the generation that will abolish abortion in our lifetime.
Amen to that. God bless. Thank you for coming out here and sharing your story. I really, really appreciate that. Let's turn our attention over to the Supreme Court. What a beautiful sight it is right now. Going on right now inside are discussions about the Texas Heartbeat Act. They started that at 10 a.m. local time. It is now 10:54. I was told that would take about an hour. Of course, it could be far longer than that. We've got some praise and worship music going on. Over to just next to us is a pro-choice rally. Earlier, they had some speakers and megaphones, and they were, I would describe them as kind of angry sounding, but they were there. That's not the case now. They are listening in on the arguments, because if you're looking for the broadcast here at the Supreme Court, you're not going to find a telecast of these discussions. Now, there is an audio feed somewhere. I don't know exactly where that link is at, so I don't even want to try to speculate where you can go find that, but that's what they're doing. They're listening to it, but we're also going to hear when Ken Paxton, Angela Paxton, and others come out here. They're going to basically tell us what they heard and what they feel like will go forward in terms of the discussion on Roe versus Wade. Talk about a patriot. Let's talk about our friend Mike Lindell. Now, we've known him to be such an advocate for election integrity. And of course, we've been here in D.C. several times talking about election integrity. But don't make any mistake about it. Mike Lindell is a big pro-life advocate. And if he was available, I'm sure he would be here today praying for all of you right now and praying for the Supreme Court justices inside. So let's help him out. Let's help that patriot out. Go to mypillow.com, mypillow.com, mystore.com, and fight back with your wallet. Fight back with your heart in terms of your financial giving and spending. Christmas is coming up. We've seen the supply chain shortages. We've seen analysts say that there's certain things that will not be on the shelves this holiday season. So get ahead of that. Liz Willis and myself was just at the MyPillow factory a few days ago. I saw their crews working 12 hours a day, pretty much cranking out thousands of products. They've got the products that will be in your home And if you use promo code RSBN at checkout, you'll get up to 66% off your entire order. So I just encourage you to load that shopping cart up, put that promo code in there, and see how much you can save. But more importantly, on this very historical day, November 1st, 2021, as we stand here in front of the Supreme Court, fighting for the life of the unborn, knowing that Mike Lindell would stand here with us if he was here. Let's go support Mike. Go to mypillow.com, mystore.com. Put that promo code RSBN at checkout, and you'll get up to 66% off your entire order. So I just want to encourage you to do that, support Mike, and in full transparency, a portion of those proceeds goes right back here to our network to help us do what we're doing here today, fighting for the unborn. I shared a personal story with you. That's why I'm here. That's why I'm standing in front of the Supreme Court on this important day in my life. But more importantly, I look back to the choices that others have made before me. And I'm just here to honor them. I'm here to honor God. And I'm here to really honor Mike Lindell, who's been such a great patriot for everything that we are fighting for in this country. MyPillow.com, MyStore.com. Go check it out. But we're here live, Supreme Court, waiting for the speakers to come out. If you're unfamiliar with the Texas Heartbeat Act, it basically prohibits an abortion to take place after 6 weeks, or which essentially is when a heartbeat is detected. That will ban abortion. Now, Mississippi has another abortion law that is in the works. But from what I understand, that would ban it at 15 weeks. So you're perhaps seeing a trend amongst conservative nations and in conservative states, I should say, and across the conservative nation, that this is something we want to completely ban, is the death and taking of an innocent life. And earlier they said pro-life is the entire life. It's not just after birth. We must protect those when they're unborn and still in the mother's womb. So this is a big topic right now, and it means so much for you guys to be here with us on this beautiful Monday here in our nation's capital. I'll give you a quick weather report. It's about 58, 60 degrees, zero wind, beautiful sunshine. It's just a great day to be out here in our nation's capital, and we're so glad that you're joining us today. I want to encourage everybody to go to our app, go to the Apple or your Android store, download our app, and be able to take this broadcast absolutely anywhere that you're at. We've got shows like Red, White, and Truth. We've got Laura Trump, Diamond and Silk. The Michael Savage Show is on our app as well. So take advantage of the fact that you've got the power of big tech in your favor, and download our app, put it on your phone. You can take this broadcast just about anywhere we go. It's absolutely free. And don't forget to go to our website as well, rsbnetwork.com/newsletter, and get that newsletter and put your email address in. It takes 1 minute to do that, and you'll be up to date on all the things that we're doing. Grace Saldana, we've got some great writers that work for us that are just really pushing out wonderful articles just about every day on various topics that are concerning to you and me. So go check out our newsletter as well, rsbnetwork.com. Find our newsletter on there, subscribe. You can also, if you feel led, to give. I mean, on a day like today, and we're out here fighting for the unborn, it's important to us, it's important to you. So I just encourage you. We are, partly funded by viewers like you. So if you could, we'd love to have any type of donation that you're willing to and able to give at this point. rsbnetwork.com/donate. rsbnetwork.com/donate. All donations are appreciated and enables this network to do what we're doing. And really out here against the big guys, against the really massive mainstream media. And we have really carved out such a niche and such a following, and we love all of our viewers. And I really want you to understand that. We all know here at Right Side Broadcasting that we would not be in existence if it wasn't for you. This was started back in 2015, 2016, and we started with just a handful of viewers. And we have built such a following, and I cannot tell you how much we appreciate you guys watching us and sharing this broadcast. I'm so happy to jump on here a little over a year ago with Right Side, and it's the best thing that I've ever been a part of in my professional career, and I'd probably say that has meaning, historical meaning. Not only did we cover the election, both elections, but we've covered all things around the election and all things Trump. And so I just want to make sure that I emphasize how much we appreciate all of you guys watching right now. Your kind notes, your remarks, your comments, your likes, your shares, your personal, coming up to us at events, telling us how much you appreciate us being here. That means the world to us. So thank you from everyone here at Right Side Broadcasting. And of course, you can continue to support us via the website, rsbnetwork.com/donate. But we're glad that you're here. If you want to follow me personally on social media, you can do that at Brian Glenn TV, Brian Glenn TV, BrianGlenn TV on Twitter, Facebook, Instagram. Well, I try to give you a little bit behind-the-scenes look at what's going on here on the social platforms when I have a chance. It's been a very busy day here. We're getting a good look of just how many people are here right now. And it seems to actually gotten a little bigger, especially on the fringes. There's only so much space right here in front of the Supreme Court, but it seems like it's gotten more and more. The street is open here. This is First Street on the northeast corner of First and Maryland. So the street is open, so they haven't shut the street down yet, but it is definitely, you can see the energy out here. You can see the praise and worship music standing behind me right now. People are wanting to come. They are wanting to show support. This is one of those things in our nation's history that are just absolutely important. And I've said this before, if you rank the top concerns for most Americans right now, yes, it's the economy. We've seen, hyperinflation. We've seen unemployment. We've seen people that there are jobs, and it doesn't really matter where you go in this country. You've probably experienced a labor shortage big time. We have people in the labor market. They're just not working. And that is partly due to a lot of stimulus that the government has given people to pretty much disincentivize them from going out and getting a job. So you've got the economy ranking number one with the price of gasoline and groceries and everything else, and electronics, if you can get them, due to the supply chain shortage. You've got economy number one. Second, you got the border. You got immigration. We've seen what's happening across our southern border. We've been down there along the Texas border. I'm hoping to get up to Arizona here shortly and to check that out as well. We've seen the impact of this radical immigration that is going on right now. We've seen the tens of thousands of people displaced across this country. And we've seen kids just simply be on a plane and flown to various states around this country. A lot of kids that have been, quote, lost in this system. It is a disarray. It is mismanaged. So you've got immigration second. And I would probably, at this point, rank up this pro-life movement up there in the top concerns of Republicans, conservatives, and as we said earlier, a lot of really non-political people that have never really had any particular side of being a conservative or a liberal or Democrat, Republican. It's been very neutral. So a big concern with people here, and we're glad that you're here with us today. We're taking a look at some, posters, balloons, a few speakers stepping up, saying a few words that from different organizations. Just a different mood here. I got to tell you, I didn't know what to expect. I knew it would be very emotional. I think it would be very, you've got a topic that's everyone's got a kind of an opinion on for the most part. I don't think there's anybody that would be neutral on it. But at this point, I would say relatively peaceful, very peaceful, I would say. You've got both sides acting as they should be. Okay, so you've got the economy, you've got immigration, and you've got the abortion topic. You've also got climate change. And I say that in a joking tone of voice because right now President Biden is over in overseas to talk about climate and the basically the threat of global climate change that's happening right now. And I just saw a report today that They are trying to push for a zero net emission by 2050 as far as your automobile industry goes, and also your energy industries goes. Don't know how realistic that is, but that's definitely a push in a very progressive direction as far as policy, implementing different restrictions on various industries to get to that net zero emission by 2050. So I don't, in my personal world, it may differ from you, but I don't see climate change being a even top 10 concern to the average American right now. I think the average American right now wants to make sure that he can put food on the table. The average American right now wants to make sure that he has enough money to get to work because of the gas prices. The average American right now wants to make sure that their family is safe from domestic terrorism. That's what their concerns are. I don't think it's whether or not the ocean has risen any X amount of feet, or this is the warmest we have had in 10 years. I think that's Mother Earth. I think that's Earth. She's been around for billions of years. You cannot control that. That's my hot take on climate change, folks. All right, but we're glad you're here today. We are on the steps of the Supreme Court, awaiting remarks from Texas Attorney Ken Paxton, Angela Paxton, and others. They'll give their remarks and discussions about what they heard in terms of the Texas Heartbeat Act. Where does it go at that point? We'll find out. Okay. All right. Okay, we got, this is what we would expect out here. A little Roe v. Wade has got to go, and that's been one of the common chants here on the pro-life side. And of course, the pro-choice side have had their choice of chants as well. They are sitting down listening to the discussion going on right now. As I said, there is no live stream for that, but you're going to get the recap here when others come out here at about, well, they were set for about 11 o'clock, but we're now sitting at 11:08 here local time here at the Supreme Court. So a few minutes delayed coming out from that. But we're glad you're joining us, and I want to encourage everybody to please share this broadcast, like it, comment on it. It's important that we are able to really break away from some of the social media shadow banning that could be potentially put on this stream due to the nature that it is a pro-life stream. So just heads up on that. And of course, if you go to Rumble, you go to our app, you're pretty much safe there as far as making comments and watching our content. That's why it's so important in this day and age to do things like that and get our app, because that's where we're going to be most protected there. But we're glad you're joining us. You can follow us on Twitter, Instagram, Facebook, Getter. What a platform Getter has turned out to be. Jason Miller, ex-Trump staffer, going and off and creating such a wonderful social media platform. So I encourage you to jump on Getter as well. Go to your app store and download Getter. It's a great social media platform where your voices are protected, your voice is heard, better imaging, better pictures, better videos, the whole thing. So Getter, and that is not an ad for Getter. We do love Getter, and we all have Getter on our phone. So I encourage you to get Getter as well. So a little bit of a little rally chant going on there. We've got the media set up basically to our right. It's almost like a media row. You've got a lot of the mainstream media set up with their temporary news desk here on the street. Going to go live, I would sure, to report all of this. Then, of course, a lot of independent journalists are out here as well covering this story. This is ground zero for Roe versus Wade and for the pro-life movement. So that's why there is so much attention on this right now. But we're glad you're joining us there. Also, let us know where you're watching us from. It's very interesting. We run our analytics to find out where in the country that you guys are watching us, but also where in the world that people are watching us. There's a lot of interest in American politics overseas. So if you're in Japan, Germany, the UK, France, Spain, Portugal, anywhere, let us know where you're watching us from. We appreciate your loyalty and your viewership, and we appreciate your support, and most of all, we appreciate your prayers for this country, that we can move forward in a godly manner and do what he wants us to do. Also, thanks to our viewers down in South America as well. We've got President Bolsonaro got the endorsement of President Trump down there just about a week ago. A lot of conservatives in Brazil, a lot of conservatives in South America, as this push from more of a kind of a globalism mindset of a socialist agenda. Countries around the world have realized that hasn't really worked out too well for them, and it has really restricted the freedoms that we are granted here in the States. So that's why you see so much attention on events like this, and really with opening up our country post a COVID era, as we see more and more discussions on mandates being imposed. We've seen a lot of discussion on people, perhaps losing their job over mandates. That has been a hot topic. I was flying in last night from Dallas. On my plane, there were several people talking about how they had 3 flights canceled in the last 2 days for no apparent reason, no reason really given other than just technical difficulties. So at that point, what you could be seeing, people starting to walk out on their jobs. So this is ground zero for freedom and liberty in this country. So people around the world are definitely watching us right now to see what we do and how we handle situations like this, and how we handle the situation with the economy, with COVID, of minimizing deaths. I just saw that the health organization released a global death of over 5 million people, landmark globally across the world. So as we move past this post-COVID era, our attention now turns to our rights, and what do our rights look like after COVID and the shutdowns and the mandates. So, and this is one of the examples right here. I mean, is the abortion issue that with appointed of President Trump's Supreme Court justices, the conservative movement technically has a 6-3 advantage over a liberal-based mindset agenda. So this could be the day that things start to turn on that. And also, this could be the day that it turns on a lot of things that affect our lives every day, with the economy and the jobs and the schools. And we're going to be, programming note here, we're going to be up in Loudoun County tonight for a Glenn Youngkin rally that will take place. It's his last rally before the election tomorrow night. McAuliffe, Youngkin squaring off, and from what I understand, Glenn Youngkin has about a 9 to 10 point lead over Democrat Terry McAuliffe, who's trying to get his old job back. Youngkin, very much a grassroots candidate, very much a political outsider, a man of the word, active in his church, active in the business community, and has generally just put, I think, a better plan for the Commonwealth of Virginia to move forward. And no one gave him a chance months ago. It was absolutely an outsider. Now he is, I guess you can consider him a very much insider to get this to win this election. But that is going to take place tomorrow. We'll be live from Youngkin's election headquarters there in Northern Virginia. That's tomorrow. But tonight we'll have his last rally. And it's really, it's parents fighting back with the school board. And that's kind of where it all started in Loudoun County. So we're going to be there as well, bringing that to you tonight. As soon as we wrap up here, we'll head out there and give you live coverage tonight. And then tomorrow for election night, we'll be here in Virginia giving that to you as well. We're glad you're joining us. We are live outside the Supreme Court here in Washington, D.C., awaiting comments from Texas Attorney General Ken Paxton and others as they give their remarks to what they heard inside from the Supreme Court reviewing the Texas Heartbeat Act. That kicked off at 10 o'clock just over an hour ago inside. That is going a little longer than expected. I don't know if that is indicative of what they're talking about, whether or not the length can say anything. If it was a relatively short discussion, that you might lean one way, or if now that it's going a little bit longer than normal, that might lean another. So I can't speculate at this point, but that's just where we're at right now. And we're waiting for those remarks to come, and we'll hear from them, and then we'll see where it goes from here. I know that we've talked about Mississippi having a very similar abortion act in place there. We'll see where that goes, and we'll see if other states follow as well. But we're glad you're here. Relatively peaceful. You've got, of course, both sides becoming very vocal. Behind me you have some praise and worship music. Maybe we'll give you a shot and let you see what the beautiful Supreme Court looks like on this Monday in D.C. Oddly enough, it's quite warm. I wasn't sure what to expect when you come to this part of the country about this time of year, is when you can get a few a few cold fronts coming through here, but it's actually warmed up quite nicely. The sun is up, the wind is calm, and the sun is out here on the Supreme Court. What a beautiful shot that is. What a gorgeous shot that is. And to mind you, what happens inside that building, I mean, our way of life, the rights, the laws that we have, is right there. It starts right there at the Supreme Court, and that's where a lot of the decisions that affects each and every one of us is taking place right now. So inside, that's where the discussion is going on. A good sizable police presence here, as you would expect on such an event like today. But like I said before, very peaceful. We got some praise and worship music going on right now. And equal justice under the law is what that says. So what a beautiful shot Gage, our cam op, is getting right now. What a beautiful shot of that building, and just all of the, think about all the history that's in there and all the decisions that have come out of that building that affect us every single day. Just remarkable that we're here today, and we want to thank you for allowing us to be here. And we're able to do it because of viewers like you. And I've said it time and time again, we can't be more appreciative of each and every one of our viewers that allow, this little old conservative news outlet make its way to the platform that we are today. Because today we are one of the leading forces in the conservative movement. We've had several people come up to us today before we came on air and was basically saying, thank you for being out here. Thank you for covering events like this, as we knew the mainstream media would be here. But I'm just curious to see if the mainstream media is going to cover the remarks from Ken Paxton and others on what they heard inside. I would imagine that they will. I would expect that they will. But there's a reason why we're here. We're here fighting for you, because a lot of times what's concerning to you is not what's concerning to the mainstream media, but it's concerning to us. So we want to bring that message to you. We want to bring the news and the information to you. We want to give you things that are concerning your life and that mean a lot to you. So we appreciate all of your support. And as I said before, we are partly viewer funded by people like you. So go to our website, rsbnetwork.com/donate, rsbnetwork.com/donate, and give what you can, because every little bit helps. In this day and age, we're trying to get out and cover a lot of these stories. It takes a lot of proceeds to do that. We don't have the, the gift of having foreign financial, backers with all of this. We don't have financial groups backing us. You're our financial group. So I encourage everybody to go to rsbnetwork.com/donate. I'm trying to see if there's any movement behind me I saw a couple cameras getting in position, just seeing if perhaps Ken Paxton and others are going to come out. Now, we were with Ken Paxton, I guess a couple of weeks ago along the border there in El Paso, giving you an idea what it looks like in that part of the border. Now, a lot of the hotbed has been down there in Del Rio, where we've seen tens and thousands of illegals coming up from all places in the world. We got Central America, Mexico, we've got Romania, we've got even people in the Middle East. So the southern border tends to be a very hot spot right now, and I'm sure we'll make our way back down there. I'm sure we'll make our way back to Yuma and go check out what's going on there in the world. Also, programming note, on November 3rd, I will be live from Arizona, Glendale, Arizona, at the Dream Center Church, where Carrie Lake is having a rally, an election integrity rally. And she's basically, well, I hate the word celebrating, but we're going to look at the 1 year anniversary of the corrupt election. So she's going to be there doing election integrity. It's got several guest speakers as well. So we'll be able to bring that to you live on November 3rd. Tonight, Youngkin's rally there in Northern Virginia. And then tomorrow, we'll be live at Youngkin's election headquarters there in Northern Virginia as well to see what could be a very historical election in the Commonwealth of Virginia. Mind you, this is the first election that's past a Biden inauguration. So we've had 10 months to kind of see what the nation looks like under the Biden administration. And so now the voters will turn out, and the pulse, the heartbeat there, is in the Commonwealth of Virginia. And we'll see exactly what people feel about what's been going on in our country. And that could be I think, a pivotal point in the 2022 election, because if we're able to let our voices be heard, that these policies that this administration has put in place, or maybe the policies that they've eliminated under the Trump administration, if we're able to get that state read and the voices from the conservative movement can be heard, that moves forward into the 2022 and really puts the Democrats, I feel, on their heels of what they've been doing before, and maybe have them reevaluate some of their narratives and some of the policies that they've put out. Because so far we've got hyperinflation, we've got supply chain issues, we've got immigration debacle. We haven't even talked about Afghanistan. So when you just look at those 3 or 4 things right there, the price of gasoline, the price of goods, people are concerned in this country. So that could change tomorrow. So we want everybody, if you live in the Commonwealth of Virginia and you're thinking for some reason, I don't necessarily need to vote, my vote doesn't count, or whatever a lot of the fake news narrative has been told, that Republicans won't show up to vote and they're kind of writing us off. Well, the latest polls say that is not the case, that Youngkin is up by 9, perhaps 10 points in the Commonwealth of Virginia. So I encourage you, if you live in the area here, you live in the state of Virginia, the Commonwealth of Virginia, go vote, because this could be the tipping point of what we really need to happen in 2022. And of course, we kind of knew this would happen in 2022 just by looking at the policies that have been in place and the way he's handled everything from the Keystone Pipeline to immigration to the Climate Paris Accord agreement, getting us back in there after Trump got us out. So much going on right now. And of course, if you've seen Joe Biden and you've seen some of the press conferences and some of the things that he is out publicly, you see how confused he looks a lot of the time. He looks like he's not a true leader. He looks like he is being led from behind, like someone's literally pushing him around, telling him where to go and how to act. That is something that I think any American, regardless of your political identification, can see at this point. So Virginia, tomorrow night is your night to make a statement and perhaps set us going forward in 2022 in the right direction. But we're glad everyone's here. Behind me, beautiful Supreme Court here. We got some praise and worship music. Before too long, Texas Attorney General Ken Paxton will make his way here. Angela Paxton as well will be here to say a few words, and they'll let us know exactly what they heard from the discussion that's going on behind us. That started at about 10 o'clock this morning, and it's now going on local time here. Just checking my thing. We're at now 11:25 here local time in D.C. So it's been going on for about an hour and a half. We'll see exactly what's going to happen there. We'll see if we can't get, I would love to get some more supporters for the pro-life and find out their story, why they're here. Everyone's got a personal story of why they are pro-life. And of course, I'm sure on the pro-choice side, everyone has an opinion on why they're pro-choice. It's an emotional topic. It's not like the budget. It's a little different than discussing the fiscal policies. It's very different than discussing a lot of the things that are in our political world. Abortion is very much an emotional issue, and it's just and to think that we can dismiss human life and give it no dignity is beyond and beyond me. So I want to see if I can talk to you. Come on, talk to you live on Right Side Broadcasting Network. Yeah. Oh, so.
I only do interviews with some people.
And it's interesting. And once you found out who I was with, you were like, I think I can do that. Okay, love your flag. Love that you're out here. Love what you're doing. You're young.
This is actually mine, though.
Well, just the way I like it. I like the fact that young people like yourself are out here on the pro-life movement.
Yeah, I think it's really important that we get involved, because our generation is the newest generation in the line of voting, and I think that's really important that we try to stick to the values that make America great in the first place.
And so your experience out here today so far has been what? You got praise and worship music behind us. A lot of, have been very peaceful. Have you seen that as well, walking around with your shirt and flag and things like that?
Yeah, it's actually really, it's been very peaceful, and I'm really grateful for that, because I was a little scared coming into today, thinking that we could face some resistance, and we do have a little bit over there, but it hasn't been anything too bad. I was actually here for the Women's March earlier this year, and thank God the police were there to block us off.
Well, what got you into the pro-life movement? I mean, does it come from a faith point of view, or why do you have the views you have?
I would say that my faith plays a part in it, although it's not the only reason. I recently got more into politics, but this became my number one issue after I did research on what abortion actually is and how it entails the taking of a human life. And from that point forward, my whole worldview changed, and this became probably my number one issue as a voter.
I think it's interesting being a young male, a young student, that you'd have such a solid opinion on this, because I think a lot of people your age don't necessarily have the take that you have, that they haven't really dug into it to find out exactly what that process is and the value of life and just how it does. It's very hurtful to the woman's body in a lot of degree.
Yeah, and the sad part is in our schools nowadays we're not really teaching about what it is, and when we do, it's usually very politically motivated. We have it at my school, Rider University. We have in our health center we have nothing but Planned Parenthood flyers all over the place, and to me that's a problem, because Planned Parenthood has oftentimes lied about what they actually do in an abortion. They've lied about about the other services that are available for them at the 3,000 plus pregnancy resource centers across the country. So yeah, I think it's very important that we educate the newer generations, and I think that it's very important that they get involved.
Yeah, I'm going to bring another one of your pro-life. I love the students for lifeaction.org. We've had several of you guys on camera already. So what brings you out here today? I was just talking to him, being a young person in this political environment. It's kind of it could be toxic at times, but what brings you out here?
Yeah, so I'm out here because I'm pro-life. We're out here to support the Texas Heartbeat Bill. I believe that every abortion ends the life of an innocent human being. So this Texas Heartbeat Bill has reduced abortions in Texas by 50%. So we're just so excited about that, and so we're out here supporting it.
I'm hearing some of the audio coming out of the hearings right now, and they said that basically Texas is violating all of these laws by doing this. That's their approach. That's kind of what their angle is and all.
Yeah, well, I mean, it's kind of crazy saying that Texas is violating all these laws when they want to say that a right to abortion is in the Constitution, which it absolutely is not. I don't know where that was written in invisible ink.
Yeah, I don't know who the first person that ever said that, but it's the most ridiculous thing I've ever heard. Or it's in our Constitution that you have the right to come to this country either. We have immigration laws that prohibit not just everybody running in here. So to the point. So what do you think? What do you think comes out of all of this right now after today? Is this going to move the pro-life movement even further?
Yeah, well, it absolutely does. Anything that we can do to get the conversation rolling helps the pro-life movement, because we are on the winning side. Whenever people hear this discussion, they don't like to talk about abortion. They don't like that word. So whenever we can get it in the news, whenever we can talk more about it, it's always good for our side. So it's really fantastic. And we're hoping that it goes in our direction. And if not, we're hoping that Dobbs goes in our direction on December 1st.
I also hope that the other states get involved with this. I know Mississippi has got something right now. I don't know if you can elaborate on that, if you know about what Mississippi is doing.
Yeah, so I believe in Mississippi it's a 15-week ban, right? Yeah, so that's what the Dobbs case is. They're trying to ban abortion at 15 weeks, which is very obvious to most Americans. I mean, you know, we know that there's significance to a heartbeat, so it seems kind of absurd that there would be any problem with banning abortion after a heartbeat can be detected. And even this is at 6 weeks. At 15 weeks, a baby is like so fully formed at that point. It just is mind-boggling that anyone would be against it.
Of course, you guys live in the Commonwealth of Virginia. Are you guys here in Virginia?
I'm here from New Jersey.
I'm actually from the state of Delaware. I go to school in New Jersey. Me and her are actually...
You got a gubernatorial race in New Jersey as well.
We do. I unfortunately can't vote in it because I live in Delaware, but we are really hoping that the more pro-life candidate in Jack Ciattarelli wins. We are actually from Students for Life at Rider University. We think it's very important that we come down here and support the state of Texas.
And I know that Glenn Youngkin, conservative, political outsider, conservative, pro-life advocate. So it's important. I was just saying before you guys came on that tomorrow could be another tipping point politically, because it'll be the first election post-Biden administration, that the American people can send a message to all states that, hey, look, you know what? We don't like the way this country's going right now. Let's change it.
Yeah, I mean, the polls are really fascinating in Virginia right now. I mean, I know that
I think he'd be up by 9 or 10 points.
No, I did not. But I know that Students for Life Action actually has people canvassing there this past weekend. So it's very exciting. We really hope that he wins. Yeah.
So do all of us as well. Yeah. Well, thank you guys so much for coming here, and hopefully we'll hear what they have to, Ken Paxton and others have to say about how this moves forward. And do you guys have other events planned that you're going? I'm sure you guys are always active around the pro-life movement.
Oh yeah, we have lots of stuff planned. We will definitely be back for Dobbs on December 1st. Yeah.
Thank you so much. I appreciate it. Thank you. Keep holding that flag. You guys are doing a great job. Great there. I always like to see these young people get involved in politics. I look back when I was in college, I wasn't necessarily politically minded. Wasn't in the interest of me, but I'm glad to see these young people are doing what they can to spread the conservative movement and can spread the pro-life movement. If you're now joining us, hey, we are live here at the steps of the Supreme Court that's just behind me. I'm listening to some of the audio coming from the Supreme Court right now. It's hard to really discern what they're saying right now, but I was told that these remarks could come at 11 o'clock. Now, obviously, that didn't happen because this is run late, but it will come immediately following Kim Paxton, Angela Paxton, and others will talk. We had earlier, we had a great broadcast. We had a few speakers come up and talk about the pro-life movement. We had a pastor come up here and talk about the pro-life movement. There's been a lot of prayer going on here at the Supreme Court. So that was the ceremonies prior to their remarks. But until then, we're just going to hang out here and show you a little bit about what's going on. I'd probably say, if I was to guesstimate the crowd here, 500, 600 people probably up and down the sidewalk here across the street. Let's see if we can flip the camera. The Capitol is located right behind the camera, and we'll pan that way to see if we can kind of give you a bird's eye view of what it looks like out here right now. Lots of media here as well, as you would expect. All the mainstream media is all set up here. They've got their, I guess, their makeshift sets that have popped up here. We're here, and we appreciate the fact that you guys have allowed us to come here. And I'll say it again, we are funded by viewers like you, good viewers like you that have allowed us to cover the events that we're doing today. So I just encourage you to go to rsbnetwork.com/donate and donate what you can, because it does, every little bit helps us do all of this, especially on today. Today we are November 1st, 2021. We're standing at the steps of the Supreme Court fighting for the unborn, fighting for life, fighting for what God wants us to do, and that's why we're here. Thanks to your generous donations. So I just encourage you, if it's in your heart right now, to drop a little something in the tip jar. We appreciate it. Go to rsbnetwork.com/donate. 100% of your donations goes right to helping us cover all of these events around the country, not just, obviously we love President Trump and we will always support President Trump and we will go wherever President Trump goes, but also big issues like this that affect millions of Americans. And that's why we're here, the pro-life movement. So I just want to appreciate everyone for supporting us there. And of course, if you want to jump ahead of the holiday season, I encourage everyone, while we wait for the speakers, you have a few minutes, right? Go to mypillow.com, mystore.com, and shop away, because now is a great time. And I'm telling you, if Mike Lindell was here right now, he's a pro-life advocate. He would be up here with us fighting for the unborn. So let's give him a favor, and let's help him out by supporting him and his company. So go to mypillow.com, mystore.com, put that promo code RSB in a checkout, and you're going to love how much you're going to save. Great time to load that shopping cart up, get those Giza sheets, get that dog bed, get those pillows. I've been on an airplane for the last 3 or 4 days now. It seems like I can't go without my travel pillow. I can't do it. Go get one. If you're going to travel this holiday season, go get one. You have, if you want the best towels in the world, go get one of those towels. They're amazing. But go to mypillow.com, mystore.com, and support Mike Lindell. He is just so much a patriot for election integrity as he is for the pro-life movement. So I just encourage you right now to go check it out. mypillow.com, mystore.com, and full transparency, portion of those proceeds goes right back to helping our network. So that is one way that you can help us out and get some quality stuff at the same time. mystore.com, mypillow.com. Hang on a second. I tell you what I'm going to do. Let's get the camera pointed on the Supreme Court. We're going to go ahead and take a little bit of that audio of what's going on right now, and then we can always pop back in here when things start to get, we have some speakers in here. We'll come back to this. Until then, let's take a listen of what's going on right now inside the Supreme Court.
In the first instance. That is the ordinary way that an ex parte Young action proceeds, and if the state had not specifically sought to thwart that mechanism here by outsourcing the enforcement authority to the general public, that kind of injunction would have been appropriate. The problem is that the state has specifically, by delegating to members of the general public this enforcement authority, it specifically made it impossible to determine in advance who is going to become an SB 8 plaintiff, who is going to actually choose to file suit. And I think in that circumstance, injunctive relief that prevents the state court proceedings from going forward is appropriate. And then the second limitation that I think the court could articulate is that this is the rare case where the mere existence or threat of the litigation is itself causing the constitutional harm. It's the flood of SB 8 enforcement suits that could be filed that is chilling the exercise of the constitutional right today. And it's not normally the case in an ordinary suit that the mere prospect that there could be a case filed would create this kind of profound harm and chilling effect on constitutional rights. But that was Texas's intent here. That was its clear purpose, and it's the actual effect, because right now in Texas, that constitutionally protected care is not available.
General, I appreciate your point. Texas, as you say, has done everything it possibly can to try to make it difficult for abortion providers to vindicate their rights under our precedents. I get it. I think it's a forceful argument. But I think we have to be concerned about the implications of the mechanisms that you propose for providing some kind of relief. A lot of your brief and all the other briefs that have been filed against Texas in both of these cases suggest that we should issue a rule that applies just to this case. But that's inconsistent with the rule of law. When we decide a case, the rule that we establish should apply to everybody who's similarly situated. And if you look at the particulars of the enforcement mechanisms, they are unprecedented and they provide cause for concern. And so I'd really like to hear your explanation about why they're appropriate and how they can be limited to this case. Start with the judges. It's unprecedented, and it is contrary to our system of federalism to enjoin a state judge even from hearing a case. When has that been done, and how can that be justified? The judge is a neutral arbiter. The judge is bound to apply the Constitution. How can you enjoin a judge from performing a lawful act, which is the adjudication of a case that is filed before the judge?
Well, I want to be perfectly precise that in our case, the district court enjoined Texas and found that that injunction could properly reach the state court personnel who would be then exercising the state's authority.
Well, Texas is an abstract entity, and an injunction has to apply to people. Yes, there are instances where a state has been enjoined, and what that means is that everybody under the control of, let's say, the state, everybody who has to follow what the state attorney general says has to comply, and the state can pick, can work out the way that would work. But that doesn't apply to state court judges.
Well, I certainly acknowledge, Justice Alito, that an injunction that would bind state court judges is extremely rare. It's not unheard of, and I think in the unprecedented facts of this case, it's appropriate relief.
Well, judges have been enjoined, let me just interrupt you. Judges have been enjoined from performing unlawful acts, but here the act that they are enjoined from performing is a lawful act. How can that be justified? Let me give you this example. Suppose an action is brought under SB 8 in federal court pursuant to diversity jurisdiction. Let's say a woman sues a doctor who has flown in from another state to perform the abortion. Would the district judge in this case have the authority to enjoin another district judge from even hearing that case?
No, I don't think that the injunction could properly reach the federal system. I don't think that there is any realistic possibility that any of these suits could possibly proceed in federal court, because the distinct feature of SB 8 is that the plaintiffs who are authorized to sue need not have any injury or suffer any harm from the prohibited abortions. And so I think the idea that there would be a proper basis for Article 3 jurisdiction is lacking.
Well, it's certainly possible to think of cases where there would be federal jurisdiction. A woman sues an out-of-state doctor in diversity under SB 8 for physical or emotional harm suffered as a result of the abortion. There's injury in fact, and the amount in controversy could be met. So your answer is one federal judge can't enjoin another federal judge, but a federal judge can enjoin state judges because they're lower creatures. That's the answer?
That is not what I mean to suggest. Here, the injunction runs against Texas, and the state court judges in Texas are being utilized by Texas to effectively create an apparatus that is so lopsided, so procedurally anomalous, and so hostile to constitutionally protected conduct that the mere existence of the suits, no matter how the judges adjudicate them, create the constitutional harm by chilling the conduct. And so we are not suggesting that the judges would do anything other than actually follow federal law here. We think each and every one of these SB 8 suits would inevitably be dismissed because the statute is so clearly unconstitutional, but that doesn't remedy the constitutional harm because the constitutionally protected care isn't being provided in the first place.
General, to achieve this injunction against state courts, do we also have to overrule Ex parte Young, where we said, now I'll just quote the relevant bit I've got before me, it's an injunction against a state court would be a violation of the whole scheme of our government. The difference between a power to enjoin an individual from doing certain things and the power to enjoin courts from proceeding in their own way to exercise jurisdiction is plain, and no power to do the latter exists because of the power to do the former. So do we have to overrule at least that aspect of Ex parte Young?
No, Justice Gorsuch. I think that that aspect of Ex parte Young has to be read in the context of the court's recognition there and the whole thrust of the opinion that the appropriate relief would run against the enforcement agents themselves.
I understand that, and that was Justice Breyer's point earlier. But Ex parte Young also said this, And I think that's just, am I wrong? How do you reconcile saying you can never enjoin a court with saying you can't hear? Something has to give, doesn't it?
Well, I certainly think that it is not uncommon in equity to have relief that is targeted to prevent a suit in law from proceeding. I acknowledge it's unusual to have that relief run against the judges themselves, and if this court has concerns with that approach, I think that the court could rightly recognize that the remedy here could focus on the clerks engaged in the ministerial task of docketing the cases, and as our injunction does, against the SB 8 plaintiffs who are actually exercising the court's enforcement authority. But I do think that the court's statement in Ex parte Young has to be read against the backdrop of this court's recognition that there would be otherwise effective relief available. And what we're confronting here is a situation where it's very difficult to find that effective relief by design because Texas designed the law specifically to thwart it.
General, do you agree that there are instances in which no federal forum is available to adjudicate a federal right?
Yes, I do agree that that is sometimes the case.
You also agree that it's sometimes the case that a federal right can only be enforced defensively and not in a pre-enforcement challenge?
Yes, that can be the case.
Can you tell us what are the elements that must be necessary for you to have to seek the kind of equitable relief that you are seeking here? Would it be limited to cases where every single one of the characteristics of SB 8 that you mentioned are present? Must they all be present? And if that is the case, is this really what you're seeking, a rule for one case?
I don't want to suggest that every single feature of SB 8 would necessarily have to be replicated, but I think that the overall inquiry would have to focus on whether the state has deliberately sought to prevent any effective means of judicial review. And here we have it both with respect to federal court. Of course, the state has sought to supplant the traditional 1983 action, Ex parte Young action, but we have it on the back end as well, where the state is trying to purposefully make these SB 8 enforcement proceedings so anomalous, procedurally anomalous, and feature rules that are so stacked in favor of plaintiffs and defendants that the clear purpose and actual effect has been to chill the right. And I think that this is a response to Justice Gorsuch's questions as well, because although it is true that sometimes there's not a federal forum to raise a federal claim, for example, with defamation, it's not the case that in those circumstances the state court proceedings are heavily weighted in favor of the plaintiffs with the evident intent to chill the speech from occurring. And the proof is in how this has actually worked in practice, because defamation actions haven't meant that no speech occurs.
Well, counsel, but we've created a whole substantive law of defamation out of concern for chilling effects. And why on that theory wouldn't we go one step further? For all the reasons you've provided, they're good reasons, and I think Justice Alito's said they're strong arguments. Why wouldn't we do the same thing for that other very vital and important right, or the Second Amendment right, or the right to free exercise of religion? They're all, we don't get to pick and choose among our rights. We're supposed to enforce them all equally. Why does this one get special treatment?
This law is different because it has taken the ordinary state court mechanism that might be an appropriate way to vindicate the rights, whatever they are, and it's purposefully sought to obstruct them.
But you'd agree that tort laws for defamation have a chilling effect.
Yes, but they have
and you'd
to chill
agree
speech
that gun control laws also have a chilling effect.
They can, but not in the same way that
And you'd agree as well that
operates.
laws restricting the exercise of religion can have a chilling effect.
I'm not denying, Justice Gorsuch, that those kinds of laws can have some measure of chilling effect on the margins, but they look nothing like this law.
You're not suggesting, General Prelogger, that this right is different, are you? If this exact law were issued by a state that wanted to be hostile to gun rights, your argument would be the same, would it not?
It would be exactly the same, because the threat here is to the supremacy of federal law that's accomplished by trying to cut off the channels of judicial review that Congress recognized in Section 1983 would be vital to vindicating federal rights, whether that's Second Amendment rights or rights to religious liberty, or here the right to abortion.
Well, doesn't matter that it's the abortion right. How about the issue of severability? You want to enjoin every action that's brought under SB 8, even though some of them would not violate Roe or Casey. And I guess the justification for that is that in the abortion context, as we held in the prior whole woman's health case, severability doesn't count. Normally, we pay attention to severability clauses, but I guess when it's abortion, if there's one provision of a statute that's unconstitutional, the whole thing sinks. Is that your position?
Well, our position is that the district court rightly applied this court's decision in Whole Woman's Health versus Hellerstedt and concluded that it would effectively amount to legislative work to walk through SB 8 and try to parse it provision by provision and application by application to determine which applications would be constitutionally permissible.
Well, is that what you want us to do if we find one provision of some massive federal statute unconstitutional down the road? Well, it's too much work to go through them all. We're just going to strike down the whole thing. You want us to do that?
The difference here, I think, that the district court recognized is that it would actually require rewriting the statute to try to reach those lawful applications. And I think in particular in this preliminary injunction posture where the court was acting on an emergency basis, that kind of parsing wasn't necessary. But if this court disagreed, I think all that would show is that the court should confine the injunction to the applications that are unlawful under Casey and Roe and make clear that the only acceptable implementation of this would be with respect to post-viability abortions. And of course, Texas already separately prohibits post-viability abortions. The providers don't provide them, so I don't think that that would have any actual real-world effect.
Can you go back to Justice Thomas's question? Imagine those columns there are filled with the California Civil Code. And let's take out those parts that don't deal with private people. So what we have are property and torts and so forth. And someone in your office says, I've been reading that. Don't ask me why. But I found 19 provisions here that I think are unconstitutional. Let's go bring a case. Now, if we accept your argument, I guess that person has a good point. I'm a little nervous. So far, what you've said to distinguish this one is you said, but here Texas purposely did this. Boy, that raises a whole nother set of issues, as you well know, when you say the legislative history counts, okay? Oh, but you say, but they're not giving a good forum in the state to test out the constitutionality. And now I think about the California Civil Code or the Procedure Code or 15 other things. I don't know. You know, is that the test? Have you sat down and thought through what are the implications of the test, or is it that the federal government, no matter who's in charge, without a statute, whatever party, whatever president, can just go and intervene in any case, can bring a federal case whenever they think a state law is affecting private people, is unconstitutional? And if not, what's the test?
No, Justice Breyer, we are not urging a broad authority to bring a suit like this in the circumstances that you identified. And I think that there are two critical distinctions here that separate those circumstances from the ones we confront with SB 8. First, here it is perfectly clear that Congress intended to have a federal court forum for the vindication of this type of claim through Section 1983, and the state is purposefully trying to manipulate it through the delegated enforcement authority and avoid that federal court forum. And second, with respect to the state court proceedings, it's not just that these proceedings, in my estimation, deny a fair forum. It's that by their very design, with respect to each and every procedural and substantive rule, they display open hostility to federal rights and try to prevent any effective forum to get statewide relief, declaring this law in violation of this court's precedents.
Thank you, counsel. I share some of the concerns that have been voiced by my colleagues. You say this case is very narrow, it's rare, it's particularly problematic, but the authority you assert to respond to it is as broad as can be. It's equity. You said we have the authority to sue states under equity, which is a limitless, ill-defined authority. And I just wonder, I know you've been asked this question before, but if you could repeat your answer. What is the limiting principle? When we get another case down the road where it's a different Solicitor General who's making this argument in a different case,
what are we going to be able to point to that says, no, you can't invoke that broad equity power, or you can't say just because there's a state statute that is enforced by private parties, which is a very common phenomenon, that you then get to sue the states?
Well, Mr. Chief Justice, the equitable remedy that we're seeking here is not limitless. It is the traditional remedy of enjoining implementation of an unconstitutional law. And the limiting principle that will
Well, it's
govern...
hardly traditional to get injunctions against judges, injunctions against clerks, injunctions against everybody, right? That's part of the relief you seek, isn't it? Anybody can bring one of these suits, so you're seeking an injunction against the world, right?
No, we're seeking an injunction against those who actually choose to involve themselves in the constitutional violation by filing suit.
Well,
so
anybody can do that. But anyway, I'm sorry.
It's true. I just wanted to be very clear that the injunction doesn't apply to the potential plaintiffs, only to the actual plaintiffs. But to try to address the concern you've raised, I think that here the limiting principle arises from the way this statute operates to try to deprive any meaningful review anywhere, whether in federal court at the outset, whether in state court on the back end through the enforcement proceedings. And I recognize that this seems like a novel case, and that's because it's a novel law. But we do not think that a recognition here that the United States can intervene to try to protect the supremacy of federal law would open the floodgates in the mine run situations where a state is simply applying a private right of action through ordinary and fair state court proceedings.
Justice Thomas?
No questions.
Justice Breyer? Justice Alito?
As to the potential private plaintiffs, how can they be bound under Rule 65 of the Federal Rules of Civil Procedure? With what party are they acting in concert?
They're acting in concert with the state of Texas, which has created the bounty that incentivizes their conduct and has created the apparatus through the enforcement proceedings that allow them to perpetuate this constitutional violation.
Not with the state, not with any individual who is a party?
That's right. We believe that they act in concert with the state, which is the named defendant here and bound by the injunction.
So would any private plaintiff bringing any common law tort suit be acting in concert with the state under the laws of which that claim is asserted?
No, but there's a world of difference between an ordinary private right of action and the exercise of that kind of private enforcement and what SB 8 contemplates.
No, I understand that, but why is the question whether they're acting in concert with the state any different? Here they're acting in concert with Texas, you say, because they are Texas law. So if somebody brings suit in Maryland under Maryland defamation law, they're acting in concert with Maryland. Is that right?
No, and we're not suggesting that every private right of action is governed by these same principles. But the key difference here is that the individuals who are SB 8 plaintiffs are actually exercising the state's own enforcement authority. This is not meant to remedy some private harm that those individuals suffered. And I think the best example or illustration of that is that the $10,000 plus bounty that the state has created is only available to the first comer. And so the suggestion that was made earlier by Texas that this could be some redress for personal outrage, I think is inconsistent with how the scheme is structured. This is meant to simply function as a method of encouraging the suits to be filed on the state's behalf. And in that circumstance, we think it can qualify as active concert or participation.
The Texas Constitution requires injury in fact, and this statute, as I understand it, permits an award of actual damages in addition to the liquidated damages. And there's nothing particularly unusual about a statute that provides for liquidated damages. So I don't understand your answer at all.
Well, Justice Alito, if that's what the statute was attempting to accomplish, then presumably it would apply those liquidated damages to every single SB 8 plaintiff. It wouldn't limit it to just the first person who is able to effectively bring to bear the coercive force of the state's enforcement authority. And so the suggestion here that the $10,000 is meant to provide a presumptive dollar amount on personal injury, I think is inconsistent with how the statute operates.
All right, so one final question. The federal rules do provide a mechanism for you to do what I gather you're trying to do with respect to these potential private plaintiffs, and that is to certify a defendant class. Did you try to do that? Have you satisfied the requirements of Rule 23 to do that?
We did not try to do that, and again, I think this relates to my answer to the Chief Justice that the injunction doesn't reach the world at large or every possible person, the anyone, anywhere who is authorized under this law to bring suit. Instead, attempted circumvention would clearly not work, and so wouldn't.
They can't sue the state the way you can because of sovereign immunity. So one of the big issues for them, and I'm not asking you to litigate their case, but I'm asking for your views of how it affects yours, is who do they sue? They haven't sued like you have all SB 8 plaintiffs who file suit. They've sued a clerk of the court, a judge, and attorney general and other state officials. So how do they get the relief that you're seeking? You've heard Justice Alito say not everybody has been named because the SB 8 plaintiffs have not been named. So how can they be bound?
That's right, Justice Sotomayor, and I think that that reflects that the relief that we're seeking is in some respects different than the relief that the providers could obtain in their suit because they don't have a mechanism to identify or sue the SB 8 plaintiffs. Here, our injunction can rightly reach those plaintiffs because the state of Texas is subject to our suit, and then the plaintiffs can be bound under Rule 65. I think that the providers, therefore, have rightly focused on trying to target the aspect of the enforcement proceedings that create the harm through the filing of the cases in the first place, and I understand that to be the basis of their request that the court recognize their claim as against the clerk class.
Thank you.
Justice Kagan?
Well, is it also possible that in the whole women's health suit, that the AG could stand in for the individual plaintiffs in the way that in your suit, the state essentially stands in for the individual plaintiffs?
I think that is possible, Justice Kagan, and so if this court concluded that the AG of Texas could properly be enjoined here in the provider's suit, then that effectively, I think, would pierce the fiction here that the state has tried to create by delegating the AG's enforcement authority to the world at large and could rightly try to target that aspect of the enforcement scheme.
Justice Gorsuch?
General, are you aware of a precedent that permits an injunction against all persons in the country, the world, the cosmos who bring suit?
No, Justice Gorsuch. So our injunction doesn't do that either.
But you said it against anyone who brings suit, right? So I did include that in my limitation. Am I missing something?
Just to be clear, and I'm sorry if I wasn't clear about this before, we understand the injunction only to bind those individuals who choose to file suit. And
yeah,
so at that point, they would be
I'm
identifiable.
asking you, counsel, are you aware of any other example of such an injunction?
With that specific term, I can't cite one to you. Again,
not in the history of the United States. You can't identify one for us, right?
In the history of the United States, no state has done what Texas has done here.
And then with respect to those individuals who would be bound, could they, for filing a lawsuit in defiance of it and then maybe filing a discovery request, some other action, be held in not possible?
That's correct.
Okay. Are you aware of another circumstance where an injunction's been issued where contempt's not possible?
Well, Justice Gorsuch, I think in any circumstance where someone didn't have notice of an injunction, contempt wouldn't be possible. That's
Is the answer no, counsel? You're not aware of one?
I think that it's actually every injunction operates that way.
Because every other injunction provides notice in advance, and this one doesn't. So this one uniquely alone wouldn't allow for contempt proceedings. Is that your argument?
No, the district court specifically tried to facilitate notice by providing.
Counsel, if you could answer my question, please. All right, you're saying that they can be entered without notice. An injunction can be entered out without notice. You're not aware of one prior to that. And I'd just like a straight answer as to whether those individuals in these circumstances could be held in criminal contempt or not.
If they did not have notice of the injunction, then no, they cannot be.
Then is this an advisory opinion saying don't file these things, we'll throw them away, but we have no contempt power to enforce the injunction?
No, because the injunction does appropriately bind Texas, and it does appropriately bind all of those individuals who exercise the state's enforcement authority.
What is an injunction without enforcement power?
There would be enforcement power here, both with respect to the state, with respect to the individuals who have actual notice and file these suits, with respect to the court personnel who would violate the terms of the injunction, and with respect to the enforcement agents at the end of the day who would be enforcing these judgments.
On the Deb's question that the Chief Justice raised, just to press that a little bit further, and an assertion of an equity right here, and I think Justice Thomas alluded to this too. Has the United States government ever before asserted this equity right to protect individual rights in any other state, ever?
Well, I want to be clear that the right that we're asserting here is to protect the supremacy of federal law. So
and I'm asking, have you ever done that to defend the supremacy of individual rights in any other situation anywhere in the country in our history?
We have brought suit before. It was a series of cases in, I believe, the 1970s that did not work their way up to this court. The United States urged a broader theory there to be able to sue to vindicate constitutional rights generally, but that's not the argument that we're making here. Instead, we are arguing that the specific thing that gives
Besides that one suit, are you aware of any others?
No, I believe there were 3 suits in that line.
Thank you.
Justice Kavanaugh?
General, in the prior case, the plaintiffs would be the same plaintiffs if it were an ordinary ex parte Young situation. General Stone would be representing a state DA or state executive official. We'd have arguments about the merits, which we're obviously not dealing with today, but it would be the same basic situation. There is an extension of ex parte Young to get to the prior cases we've talked about, and that's an important step that we have to analyze. Your case, by contrast, though, seems, and I'm probably repeating others' questions, just different and irregular and unusual, and we don't know where it goes. And I just, if you could fill in, and maybe this will be repetitive, but you think the U.S. has authority to bring a suit like this against any state law that
violates this court's precedents and tries to shield that violation from any effective judicial review in federal or state court. And I recognize, Justice Kavanaugh, that this is an unusual suit. The United States does not lightly invoke an authority like this to sue a state. The reason we've done it here is because SB 8 is so unprecedented, extraordinary, and extraordinarily dangerous for our constitutional structure. If Texas is correct that it can nullify this court's precedents and it can successfully evade the mechanisms that this court recognized.
There was an open question about something, and a state wanted to kind of draw a line with respect to the precedent. Would the U.S. have the authority there? Is there something about what you think is the clarity of the violation here that triggers your authority?
If the state structured that hypothetical law in this same way, then we would have the same concern that the state is effectively seeking to take the issue away from the courts. And so you can imagine a circumstance where a right is more unsettled. Imagine, for example, in a pre-Heller circumstance, the right to possess handguns in the home. If D.C. had enacted a law that deputized members of the general public to seek these kinds of suits against that conduct, even before the court had clarified the right, I think that that would have raised the same concern that effectively the state is seeking to box the judiciary out of being the final arbiter of constitutional rights. Now, I will say that I think that a state is far less likely to engage in this kind of mechanism with an unsettled right because it would think that its law is constitutional, and I would assume that it would want to forthrightly defend it and get a court ruling that confirms that point. But if a state instead sought to shield the law through this mechanism, it would raise the Supremacy Clause concern.
Thank you.
Justice Barrett?
I just want to follow up briefly on the questions that Justice Kagan and Justice Sotomayor were asking you about what happens to your suit if the plaintiffs in the Whole Women's Health suit prevail. Let's imagine that they do prevail on a theory that the Attorney General has this residuum of authority and that the private parties can be bound as state actors pursuant to Rule 65. You told Justice Sotomayor that then the United States' interests would not dissipate even in that scenario, and I guess I didn't understand that. You phrased it, I think, in the past tense, that wouldn't cure the affront to sovereignty that was already there. But you know, the force of your argument for equity here is the inadequacy of a remedy at law because of the way that Texas has cut off access to the ex parte Young remedy. So could you just explain to me why your suit would continue to be live or why there would be an argument in favor of it if Justice Sotomayor's hypothetical were in play?
Yes, of course, Justice Barrett, and I appreciate the chance to clarify. I don't mean to suggest that the suits wouldn't interact with each other with respect to what kind of equitable relief would be appropriate. I understood Justice Sotomayor to be asking me whether our suit is effectively contingent on the whole women's health litigation, and my response was that you have to measure the sovereign injury here at the time the statute was enacted. And when the statute was enacted, it was clear that Texas was seeking to deprive others of having an opportunity to go to federal court for a remedy. The law was unsettled, and it was apparent, and in fact has been the effect, that Texas has succeeded in being able to nullify the right currently while these cases are working their way through the courts. But I do think that if this court provided guidance in whole women's health and made clear that a state cannot succeed with what Texas has attempted to do here, then we wouldn't have that same circumvention concern in the future. But in all candor, the concern is that then a state might seek to legislate around whatever the whole women's health decision says. It might try to tweak its enforcement mechanism in some way to get around that ruling. And I think that what that shows is that when a state attempts to thwart judicial review and creates that possibility that the supremacy of this court's decisions will not be respected, the United States may sue in equity to redress that harm.
So it would be kind of a pile-on injunction, like they would have an injunction against the Attorney General and the private plaintiffs acting, as state actors, and then we would also enjoin, let's say that we didn't want to enjoin the clerks and the entire apparatus of the state. Let's say that we thought you too, in getting an injunction against the state of Texas, could really only obtain one against the executive officials who would enforce the law. You're asking just for the same injunction in your suit, but just acknowledging that the United States has the ability to bring this kind of in re deb suit?
Well, I think that it's important to separate out the question of authority to sue with what kind of relief might be appropriate. So we do think that when we filed this suit, and at that point, of course, there was no relief being provided on the ground in Texas. This law had taken effect and it had chilled a constitutionally protected right out of existence, that at that point we were authorized to bring suit. The question of what the appropriate remedy would be, I think, is a separate one, and I think it very well could be the case that there would not be a need for duplicative injunctive remedies in both of these cases, but that's a separate and distinct question from whether we could sue in the first place.
Thank you.
Thank you. General Stone, welcome back.
It's been a long time. Thank you again, Mr. Chief Justice, and may it please the court. The Department of Justice's suit offends the separation of powers by usurping for the executive branch the role Congress plays in determining what cases may be heard and what remedies may be provided in the federal courts. As discussed earlier this morning, no Texas official is a proper defendant in a pre-enforcement challenge to SB 8. The United States cannot cure that problem by naming the state of Texas as a nominal defendant and then asking for relief that runs against the same Texas officials that are inappropriate targets for an injunction under bedrock Article 3 and equitable principles. Moreover, the United States is not a proper plaintiff. It cannot claim a sovereign interest in suing to enforce individual rights under Casey, and the remedy it seeks would be completely foreign to traditional equity. Congress must create such novel remedies if they are to exist at all. And Congress has impliedly rejected giving the United States such relief by providing other avenues to vindicate 14th Amendment rights. Like the petitioners in Whole Women's Health, the United States asks this court to disregard all of this because it deems SB 8 a novel solution for which a novel problem for which this court must concoct a novel solution. Even if it were, and it is not, such a request must be directed to Congress. The United States cannot seriously assert that the Constitution requires pre-enforcement federal judicial review. It opposes that result in virtually every other case. This court should reject its request for a special forum, remedy, and cause of action for this case alone. I welcome the court's questions.
Is there any instance in which the United States can do what it's doing now that would be acceptable to you? That is that, let's say there is no question whatsoever that a state is defying a national law or a federal law or a constitutional provision, such as, for example, the Second Amendment? Is there any instance in which the United States can step in?
So, Your Honor, I have to first clarify, are you saying with a cause of action provided by Congress or only in this in re debs style stop?
In re debs.
Your Honor, to the extent that Congress had provided either a proprietary right or had recognized a public harm in the form of a statute, for example, the Interstate Commerce Act, and then also the United States was seeking a traditional form of equitable relief, such as in debs to abate a public nuisance, then it could proceed.
So a very narrow set of cases.
Yes, Your Honor, but some.
A separate question. I'm interested in the cases that are proceeding in state court, this is a carryover from the first case. What remedies could be provided in those cases if they were allowed to proceed?
Well, an individual could receive, for example, an injunction preventing the bringing of an enforcement action or by bringing a lawsuit by the plaintiff who seeks to do so. Now, of course, as discussed earlier to Justice Barrett, that would only provide relief as against that one individual. But the more important part here is that eventually those sorts of cases be decided on stare decisis grounds by appellate courts, which would prevent follow-on cases to some extent. But in terms of relief, you get declarations basically out of the Texas state system. A declaration that an application of SB 8 against an individual, I misspoke earlier with an injunction, I'm sorry, that a declaration that an SB 8 claim by that individual against the protected conduct that someone was raising would violate state law, federal law, whatever the claim might be.
And one final point, why wouldn't, and I think I've alluded to this before and asked this before, why wouldn't these private individuals be considered private attorneys generals? Because so much seems to be, one thing that seems rather implicit on the other side is that they are in effect, if not in designation by law, attorneys generals, because they are enforcing a statewide policy. So your argument, again, would be that they are not private attorneys general because, or they are not acting in concert, they're not deputized, they're not agents because.
Because they're not subject to the state's control, they don't have access to the state's investigatory resources, the state can't at some point, for example, or take the case over like in a key TAM action, those sorts of answers that I was providing earlier, Justice Thomas. But my answer would run specifically to the lack of control between the state with regards to an SB 8 private plaintiff suit.
Let me think about just a specific example, which was the worst one I could think of for you. I mean, suppose the Governor Falbus, had this model law and said anyone who brings a black child to a white school is subject to, and then we copy the law. There we are. Now, if you were in that situation, which I'm sure you're glad you're not, what? What would you do? I mean, if we uphold this, are we retroactively upholding that?
No, Your Honor. As a matter of fact, for that very specific case, Congress has specifically provided DOJ.
No, this is before Congress. I mean, 57, Congress was no help. I mean, believe me, they did nothing. Or if they did something, I'm unaware of it. And if they did something, I assume it out of the hypothetical.
Fair enough. Fair enough, Your Honor. The answer would be that there would have to be recourse, again, to the state court. I'm assuming this is a state legislature because we're talking about federal court.
This was Arkansas in 1957.
Sure, Your Honor. And that, in fact, that court would be obligated to apply this court's decisions. That's a transparent violation of the 14th Amendment, of course, Your Honor. We have to assume that state court judges...
Yeah, but they didn't. I mean, we have some experience. And most of those cases that came up in that period to this court, the judges were aware of that experience, and they tried to shape the law to avoid it. So is there anything you can think of? I'm getting your answer is no. You cannot think of anything. The only thing we would have to have said then is well, it's up to the state of Arkansas's judges
The problem, Your Honor, is that the number one answer to your question is the thing you've asked me to assume away, which is the thing Congress has actually done, which is in 42 U.S.C. 2000 C6 specifically provided a cause of action for the United States to maintain a cause of action under the Equal Protection Clause.
Can I give you examples where Congress has it? A state dissatisfied with Heller says, anyone who possesses a firearm anywhere is subject to litigation by any private citizen anywhere in the country and gets $1 million bounty. No stare decisis, no nothing. How about in Obergefell, imposes SBA-style liability on anyone who officiates, aids, or abets a same-sex wedding? How about dissatisfied with Lawrence versus Texas, subjects a private consensual sexual conduct of which it disapproved to the exact same law as SBA 8. How about Griswold? The use and sale of contraception is subject to SBA-style liability. So this is not limited to abortion. That's the point that's been raised. It's limited to any law that a state thinks it's dissatisfied with.
Your Honor, I've at no point in the earlier argument or this one asserted that the extent of federal courts or federal court availability turns on the underlying right here. Quite the opposite.
So
I agree with you,
your
it
point
doesn't.
is that no matter how much a state intends to chill the exercise of a constitutional right, as the chief said, imposing $1 million liability for an act, which I think almost any sane person except a couple of billionaires might choose to resist, that does not give anyone a right to a federal forum when the state has deputized every citizen to act on its behalf.
No, Your Honor, it does not create federal jurisdiction as a consequence. I do want, however, in the spirit of the hypotheticals you're delivering, want to return to a point that Justice Barrett made at the end of my friend's previous argument. At a very minimum, to the extent that this court believes it has to somehow alter the ex parte Young fiction, et cetera, to find a way to allow the plaintiffs in Whole Women's Health to proceed, at a minimum, the United States' case must thereby fail. The United States just conceded up here that whatever interest they had would be purely retrospective, as of course, there being some sort of ability to vindicate the rights that Whole Women's Health and other petitioners are trying to provide. They only seek a preliminary injunction, which is by definition exclusively prospective relief, and they cannot possibly maintain their action any further. It goes exactly one way. If the petitioners in Whole Women's Health have some sort of avenue of relief, then the United States must not, which makes sense given for the extraordinary cause of action that they're trying to bring here. Congress has provided the United States, certainly at times, sometimes with truly extraordinary powers, such as the power of preclearance under the Voting Rights Act, to give one extraordinary example. The United States here would want effectively a follow-on injunction for, in their words, in the event that the state of Texas changed its law or otherwise tried to, in a way of uncharitably putting it, if the state of Texas changed its law to comply with this court's law, and yet nonetheless have something like SB 8. We have a term for when a state is put into a state where they have to get the federal government's approval before it makes a relevant legal change, and that's called preclearance. That's precisely the kind of injunction my friend on the other side was speaking of. So it can't possibly be the case they'd be entitled to that sort of remedy, just as a matter of course, in the event that Whole Women's Health succeeds or prevails to any extent. That's just one component of the extraordinary expansion. I'm sorry, sorry, Justice Kavanaugh, I thought you were going to ask me a question. Just one component of the extraordinary expansion of federal power that the United States is asking for here. Not only are they claiming a brand new sovereign interest, which can be synthesized one of two ways, either in ensuring the vindication of individual rights underneath this court's pronouncements in Casey in substantive due process, or apparently a sovereign right to ensure the expansion of access to the federal courts. Because after all, Section 1983 and Congress's various statutes that compose the federal courts, they stand as they stand. Texas understands them as is this court. They stand for what they are. The United States can't possibly have a sovereign interest in extending the application of those doctrines to apply to cases to which they don't, just because they deem this a very important case.
General, if I understand your answer to Justice Sotomayor, it was, well, even if That's a really good question that I don't have an answer to in the other case. I do have an answer to it in this case. And that's fine. That's, you know, here you are, we're in this case now. But I guess I just would like to take you back to the other case and to ask you to answer the question that you said you wanted to avoid for Justice Sotomayor.
I'm sorry, Your Honor. I thought I'd agreed that it doesn't depend on the nature of the right being asserted, and that also we could sort of raise the potential sanction as high as possible, and that wouldn't affect federal court availability. I'm sorry. I thought I'd answered that, but to make my answer expressly clear. Okay. The other dimension in which the United States is asking for an extraordinary power is the nature of the remedy they're seeking.
I guess I do want to ask a question about that, though. I mean, if that's right, you know, and we say that, we would live in a very different world from the world we live in today. Essentially, we would be inviting states, all 50 of them, with respect to their unpreferred constitutional rights, to try to nullify the law that this court has laid down as to the content of those rights. I mean, that was something that until this law came along, no state dreamed of doing. And essentially, we would be like, we're open for, you're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead.
Respectfully, Your Honor, I have to disagree with you on 2 points. The first one being the state of Texas has nullified anything. The state of Texas specifically set up in state law a recognition of this court's holdings in Casey, providing an undue burden defense, particularly to recognize that this court's holdings bind state courts in their adjudication. And of course, the federal constitutional right can and must be made available in those state courts regardless. The second point being, to the extent that we're talking about sort of the extremist hypothetical where it's a $5 billion sanction, and by the way, court is on the moon.
But by the way, this seems a pretty extremist hypothetical actual, you know? I mean, because the actual provisions in this law have prevented every woman in Texas from exercising a constitutional right as declared by this court. That's just not a hypothetical. That's an actual.
That's just not true, Your Honor. There's evidence in the record that estimates that the number of abortions occurring right now in Texas is between 50 and 63%.
I'm sorry. You're exactly right. I should have said every woman in Texas who has not learned and has not made a decision before 6 weeks.
Respectfully, Your Honor, there's a big difference between asserting that a state has structured its courts to defy federal law to completely extinguish a right and saying that a state has codified specifically this court's holdings in the applicable case, and then also to that extent the deterrent effect has caused some diminution of the exercise of that right. That's a very substantial difference, and it's certainly a substantial difference for purposes of the judges of the courts of the states of Texas. So again, just if I may, to go back to the extraordinary nature of the kind of remedy that the federal government is seeking in this
Just on the question of the kind of law, HB 1280, which is passed around the same time as I understand it, which is the law that, the trigger law, so to speak, that has ordinary enforcement mechanisms, as I understand it. Criminal sanction, enforced by the state, civil. And if you pair that with this law, it looks like this law was designed to avoid the review that law kind of openly would be available.
No doubt Texas, just like every other state when passing its laws, is well aware of the limits of federal jurisdiction in federal courts, and no doubt Texas crafted its law in part because it wanted to avoid federal pre-enforcement challenges as opposed to having those challenges in state court. I agree, that's an obvious purpose of this law, or one of the obvious ways that this law functions. That having been said, Texas doesn't commit a constitutional wrong by channeling its state court challenges into state court. That is not an independent that's not an independent constitutional obligation that Texas is under. It doesn't have to sort of fly blind as far as the collateral effects of what kinds of challenges it will receive when it decides how to structure a law.
But it does have an obligation to respect people's federal constitutional rights.
Absolutely, Your Honor, and again...
So if it's attempting to stifle those rights, chill their exercise, and keep plaintiffs away from a 1983 action and ex parte Young liability. You say there's nothing wrong with that?
Your Honor, the limits of Section 1983 and ex parte Young's availability, specifically 1983, though Congress could extend ex parte Young, are a matter of Congress. The idea that Texas would design a tort statute or design a form of liability that takes that in mind and then says these claims have to go through the state tort system, the state court system. Texas judges are presumed by this court and by, for that matter, appellate judges in Texas to follow this court's precedents fully and faithfully. Texas does not suppress any substantive right by saying that it prefers to see certain kinds of challenges brought through the state court system. And to the extent that one or more Texas state court judges fail to fully apply and faithfully apply this court's precedents regarding Casey or any other constitutional right, this court is and always is the supreme arbiter of properly presented questions.
The problem they raise, and I'll just have you answer it, is they say this law is designed to avoid all judicial review because the penalties that are imposed for violation are so substantial. And then you combine that with the retroactivity provision that people aren't going to be willing to engage in activity that's prohibited by this law. So there'll be no federal court review up front, no state court review on the back end, which is the exact ex parte Young situation, put aside the named party, but that's the exact situation. Can you respond to that?
Of course, Your Honor. 2 points. The first one being that the procedural mechanisms, the attorney's fees shifting provision and a preferential venue provision, to the extent that those things would be sufficient to effectively deny someone access to the courts standing on their own, then there are an awful lot of statutes and tort actions that deny access to the courts on their own. I mean, another complaint of my friends on the other side in Holman's Health was regarding the lack of non-mutual collateral estoppel. Well, this court has held that there are certain applications of non-mutual collateral estoppel that violate due process. It's never been a violation of due process to not import that doctrine into a state adjudication system. So I think what we're left with here is the $10,000 potential damages award or actual damages that's doing the chilling. And to the extent that we're
General
talking—
Stone, I think it's the combination of everything. You know, it's the $10,000 and it's everything that Justice Kavanaugh said and it's other provisions behind. And we've had a little experiment here and we've seen what the chilling effect is. You know, usually in these chilling effect cases, we're kind of guessing. Well, this would sort of chill me. Here we're not guessing. We know exactly what has happened as a result of this law. It has chilled everybody on the ground.
Your Honor, to the extent that we're talking about whether one or more of these procedural mechanisms might itself end up being a burden in the undue burden sense, an individual—
Please finish your answer.
Thank you. An individual could themselves raise one of these procedural mechanisms or compliance with them in the state court action and say, this particular fees provision defending this action actually is an undue burden on me because it prevents me from raising my undue burden right itself. Or perhaps, for example, a petition clause or due process clause. There might be other constitutional clauses that would protect an individual who's placed into a situation where the rules of a court itself prevent them from exercising an undue burden right. But still what that wouldn't get you is access to pre-enforcement federal review of the substantive due process right that an action under SB 8 may or may not implicate.
Thank you, counsel. Justice Thomas, anything further? Justice Breyer? Justice Alito?
If some abortions have been chilled, is there any way to determine the degree to which that is the result of the potential for SB 8 suits or from the degree to which it is attributable to the fear of liability if Roe or Casey is altered?
I don't think there's a way of being able to disaggregate those, Justice Alito, and undoubtedly individuals engaging in protected conduct that believe the protection might be removed or reasonably believe that. Undoubtedly, there's an extra kind of chill they feel, but that's not attributable to the state or to anyone else for that matter.
Would the issuance of the injunction sought by the United States have any effect on liability for abortions performed after the effective date of this act?
So it wouldn't have prevention of liability. It might stop anyone from filing a lawsuit. But of course, an injunction preventing someone from filing a lawsuit doesn't prevent a state law from being effective in the event they could file in another forum or in some way they're not covered by the injunction, Your Honor.
Well, if the injunction were entered and abortions were performed, would that immunize the abortion providers subsequently from liability?
No, Your Honor. All that would do would be preventing the individuals who had notice of the injunction. First, they'd have to have an opportunity to respond before they were enjoined, but let's skip over all of those injunctive problems. Those individuals would merely not be able to bring SB 8 suits. It wouldn't somehow dissolve in the abstract liability under SB 8 for performing the abortions.
Thank you.
Justice Sotomayor? No. Justice King? Gorsuch? Justice Kavanaugh?
Can I just get more clarity about how you think that retroactivity provision works? Are you saying that if an injunction were entered and someone, some clinic performed abortions now that were then legal under current law, but the law changes in the future such that the state could, going forward, restrict abortions at an earlier time? Are you saying that the state that could then reach back and retroactively, or allow suits that would reach back and retroactively impose liability on entities that were committing lawful acts as of the time?
It would be private plaintiffs again, Your Honor, but of course—
Is that a yes?
Yes, Your Honor, yes.
And is there any limit on that retroactive liability?
There might be, again, I have to hypothesize perhaps a due process claim if it were in some extreme circumstance, but no, there's nothing on the face of SB 8 that would provide it.
And doesn't that play into the chilling effect argument that was being raised, that presumably one of the concerns is even though you would challenge it today and think you would engage in the activity today because you would be confident, you're chilled by the prospect of future changes and then someone reaching back and imposing millions and millions of dollars, right?
Perhaps so, Your Honor, but I think that's—
almost certainly so, right? Millions and millions retroactively imposed, even though the activity was perfectly lawful under all court orders and precedent at the time it was undertaken, right?
Undoubtedly, Your Honor.
Okay.
Justice Barrett?
Just have one question. So we're talking about pre-enforcement review and the chilling effect. So if not available, your position is it's not available in federal court, and you pointed out when you were talking to me before in the last case that in state court it's not available in the ex parte Young sense, in which you could obtain an injunction that would altogether protect you from enforcement activity, but you could on a case-by-case basis obtain an injunction against individual plaintiffs. You pointed out that that might ultimately give you more protection because it would go up the chain and there would be stare decisis effect. What if, in addition to the other procedural obstacles that the law contains here, the legislature also added a provision saying there would be no stare decisis effect of any decision reached by the Texas Supreme Court?
Then, Your Honor, I would assume it would make it even more imperative for one of those cases to be taken up by this court to resolve any questions that were presented there. But that would mean that would be the only final way that you could have binding stare decisis effect.
Thank you.
Thank you, counsel. Mr. Mitchell?
Mr. Chief Justice, and may it please the court. The interveners intend to sue those who violate Senate Bill 8, but only in response to conduct that falls outside the protections of Roe and Casey. The United States cannot seek or obtain relief that thwarts the enforcement of SB 8 in those situations. The statute contains emphatic severability and saving construction requirements, and courts are obligated to preserve the constitutional applications of statutes to the maximum possible extent. The United States also cannot seek or obtain relief that would prevent private individuals from suing under SB 8, because any such relief would be a flagrant violation of the Due Process Clause. A federal court cannot ban private individuals from petitioning the courts in a case to which they have not been made a party. And a federal court cannot foreclose those individuals from suing under SB 8 when they have been given no opportunity to defend the merits of the lawsuit that they intend to bring. I welcome the court's questions.
I guess one would be, you've heard the exchanges with General Prelogger about the breadth of the asserted federal right.
Yes.
And she offered some answers to those questions about the limited nature, and I wanted to get your reaction to that.
Yes, and Chief Justice Roberts, as I understand the United States' argument, as they've spelled it out on pages 10 and 20 of their brief, the asserted sovereign interest that they're making under NRA Debs depends entirely on the existence of a congressional enactment, Section 1983, that does not go far enough in the views of the United States. What they're saying with respect to their sovereign interest is that Texas is thwarting Section 1983 and Ex parte Young by enacting a statute that is not subject to pre-enforcement challenge under either of those sources of law. That, to us, is not in any way a sovereign interest under Debs. That's a grievance with Congress, that Congress enacted a law, but Congress's law doesn't go far enough for the United States because Texas has found a gap in this congressionally created remedial scheme that allows its law to escape pre-enforcement judicial review. The proper response in that situation is to go to Congress and ask Congress to amend the remedies that they have set forth, either by abrogating state sovereign immunity or perhaps by enacting the Women's Health Protection Act, which would preempt SB 8 and also abrogate state immunity and give the Attorney General the explicit cause of action. But in no way can equity be invoked to patch up the holes or the perceived holes in a statute that Congress has enacted. The second issue with respect to the sovereign interest that the United States asserts surrounds Ex parte Young, because they claim in their brief that Ex parte Young does not go far enough in authorizing a pre-enforcement challenge. And that too runs into the problem of Grupo Mexicano. There is clearly a traditional cause of action in equity for an individual to sue an individual officer that is violating his federally protected rights. But there is no traditional cause of action or remedy in equity that would ever allow a court to enjoin the state judiciary from even hearing a case that has yet to be filed. And Ex parte Young explicitly disclaims any such remedy on page 163 when it says that an injunction against the state court would be a violation of our whole scheme of government. So what do you... Well,
but at the same time, subsequent cases suggest that that language can't be read as broadly as you suggest. Shelley against Kramer, Terry against Adams, some of the others where they've recognized that courts can be viewed as a part of the mechanism of enforcing particular rights.
That's true. But in neither of those cases that Your Honor cited was there an injunction directed at the state judiciary itself. And under Grupo Mexicano, equitable remedies must be limited to those that were traditionally available in equity. And Ex parte Young makes clear that a remedy that would enjoin or restrain a state court or a state judge from even considering a case is not a remedy that was traditionally available in equity. So it's impossible to escape the conclusion that this relief requested by the United States is barred by Grupo Mexicano.
Well, Grupo Mexicano is notoriously cryptic. But Shelley against Kramer, Terry against Adams, they aren't really. I mean, if you look at Justice Frankfurter's opinion in Terry, he says, you know, somewhere, somehow, to some extent, you have to have some participation. That seems like pretty flexible standard.
Well, again, in Terry against Adams, the cause of action was undisputed. The existence of an Article III case or controversy was undisputed. And those are the two obstacles here that the United States must confront. So the fact that there is case law out there in which relief has been granted in similar situations, involving situations where there was no question of the existence of an Article III case or controversy and no question of the existence of a cause of action, does not give any leverage to the United States' argument here, when the very objection we're making is that they can't bring suit because there's no Article III case or controversy under Muskrat, and on top of that, they can't bring suit because there's no cause of action in equity, because the relief they seek is not relief that is traditionally available.
Well, there is an Article III case or controversy with respect to the clerks, right? It's a direct adversity. The clerks want to file the action, and the plaintiffs don't want them to.
True, but the clerks aren't the named defendants in this lawsuit. Only the state of Texas is. And under Muskrat, you cannot sue the sovereign entity when your complaint is that the sovereign is allowing its courts to adjudicate cases under a statute that you believe to be unconstitutional. It would be no different from the abortion providers suing the United States government because they're allowing SB 8 enforcement lawsuits to be heard under the diversity jurisdiction. There wouldn't be a case or controversy with the United States simply because it's opening its courtroom doors to these claims. What they would have to do is wait for the cases to be filed and then assert their constitutional challenges to the statute in that litigation between the private citizens.
Do you agree, to follow up on the Chief Justice's questions, that
Supreme Court
state clerks, court clerks, and state judges enforce state law when they entertain private civil suits?
No, I don't believe they can be said to be enforcing state law in those situations.
How do you deal with
Angel Paxton and others will give their response to what you're hearing right now. We'll go back inside the Supreme Court.
Judgment has been entered by the court, and then the judgment is being enforced. But simply adjudicating a case at the outset and simply docketing a complaint, that is not enforcement. And this goes to another problem with the remedy that the United States is seeking with respect to the private individuals. They're asking the court to restrain Texas from adjudicating lawsuits. They want to stop the clerks from docketing the complaints. They want to stop the judges from hearing or presiding over the cases. And then they say that injunction should extend to private individuals under Rule 65D2C. The problem is the private individuals aren't doing any of those things that the state has been enjoined from doing. They're doing something entirely different. They're the ones who are filing the lawsuits. And the state can't file the lawsuit because it's not allowed to file it under the statute, and it therefore can't be enjoined from doing so because an injunction against the state that tells it not to file a lawsuit is enjoining the state from doing something that it never would have done in the first place. So there's another major problem with trying to get private individuals covered by this injunction that the district court laid out. The only conduct that private individuals are engaged in is conduct that the state of Texas is not.
Counsel, a state is an idealized entity. The whole fiction of Ex parte Young, it had to be created because a state, qua state, can't act. It can only designate people to act for it. And so if the state is designating, whether it's ordinary citizens or the Attorney General or its district attorneys, if it's designating those people to act for it, why aren't those people bound by any judgment that says, state, what you're doing is unconstitutional? And no agent of yours can enforce this law, whether it's ordinary citizens, the Attorney General, state licensing officials, clerks of court, or, as Shelley recognized, a court system that would enforce a restricted covenant demanding segregation. Why aren't we in exactly that same position?
They would be bound if they can satisfy the test of Rule 65D2C, which says they have to be acting in active concert.
Why? They are.
No.
Each of them is acting under the directives of the state law. So why aren't they acting like the state when they act?
Justice Sotomayor, I respectfully disagree with that characterization.
I know you disagree, but
I'm going to explain why I disagree with it. The state is not in any way directing the activity. May I answer?
Please.
The state is not directing the activity of these private individuals. The state has passed a law that gives them the option to sue, and then it has washed its hands of the matter. So there is no joint participation with the state in their decision.
How is that any different than there being state action when a prosecutor exercises a discriminatory Paxton challenge? Or how is there state action when state primary actors exclude races or exclude people from primaries? And we've called that state action, even though the state has just given them the authority to act with no control over what they're going to do.
Right.
So we have recognized that that washing your hands doesn't insulate a state.
With your example on the prosecutor.
Or insulate people from acting on behalf of the state.
Yes. The prosecutor, in your hypothetical, is an employee of the state. He's part of the state government. He's part of the machinery of state. The white primary example is a more difficult question because they were formally established as a private entity.
Are you suggesting that states can hire agents to do unconstitutional acts?
No, they cannot hire agents.
So how can the state designate a private individual
because
to act on under its laws to violate a person's constitutional rights?
Because there's not an agency relationship here, Justice Sotomayor.
It's saying to it, you under this law, our law, you can act.
I see my time has long expired. May I continue to answer? Or
briefly.
Yes, I'm sorry. Justice Sotomayor, if there were an agency relationship, then Your Honor would be correct. They would be bound by an injunction under the principles of Rule 65. But there's no agency relationship here because the state is statutorily forbidden to enforce the law or have any enforcement role whatsoever. That role is given to private citizens. The state can't have any involvement, so there can't be joint conduct with the state with respect to that particular activity.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Justice Barrett? Okay. Thank you, counsel.
Thank you, Your Honors.
Rebuttal?
Thank you, Mr. Chief Justice. I'd like to just make 3 points in rebuttal. And I'd like to begin with the point that I understood General Stone to be making, that if this court ultimately concludes in Whole Women's Health that the providers can sue, that the authority we're claiming here to sue as well is extraordinary or unprecedented. And I think it is important to recognize that when the United States of America filed this suit to try to redress the harm to the supremacy of federal law in Texas, the Whole Women's Health providers had not been able to obtain any effective redress from the courts. The law had been permitted to take effect, and it had immediately had its intended operation of chilling the exercise of constitutionally protected conduct altogether, so that abortions that are protected under Roe and Casey after 6 weeks of pregnancy could not occur at all. And I think that that shows the threat to the supremacy that comes from this attempted design of a law to block access to the judiciary. It may well be, and I hope that this court holds in Whole Women's Health, that the providers can move forward, but that hasn't stopped the harm to the sovereign interest of the United States in the meantime, as Texas has succeeded, while these novel issues worked their way through the courts, in blocking access to care that is protected under this court's precedents. And that leads me to my second point, which is to emphasize the nature of the sovereign interest here. It is in preventing a state from being able to act in direct defiance of this court's precedents and block access to the judicial review that Congress and this court have deemed necessary to vindicate federal rights, and to further make it the state court mechanism that might provide some alternative basis for raising those constitutional claims wholly ineffective and unavailable. The final point is to just step back for a moment and think about the startling implications of Texas's argument here. Across the arguments this morning, Texas's position is that no one can sue, not the women whose rights are most directly affected, not the providers who have been chilled in being able to provide those women with care, and not the United States in this suit. They say that federal courts just have no authority under existing law to provide any mechanism to redress that harm. And if that is true, if a state can just take this simple mechanism of taking its enforcement authority and giving it to the general public, backed up with a bounty of $10,000 or $1 million, if they can do that, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs, and it cannot be the law. Our constitutional guarantees cannot be that fragile, and the supremacy of federal law cannot be that easily subject to manipulation. So we would ask this court to hold that the United States can proceed with this action and affirm the preliminary injunction entered by the district court and immediately vacate the stay that the Fifth Circuit entered in this case, so that Texas cannot continue to deny women in its borders a right protected by this court's precedents one day longer.
All right, that wraps up about
Thank you, counsel. The case is submitted.
Of discussion in
the
regards
Honorable
to the
Court
Texas
is now adjourned
Heartbeat
until
Bill
tomorrow
Act here
at
the
10
Supreme
o'clock.
Court in Washington, D.C. If you're just now joining us, welcome. We are live now. We are awaiting a press conference that will go over some of the remarks that was told today. Attorney General of Texas, Ken Paxton, Angela Paxton, and others will be here to maybe give a little insight of what is going on, right, what we just now heard. All right, just getting people in place here. Several organizations are here in front of the Supreme Court getting ready to not only show their support, but say a few words as well. This started about 10:20 here local time. The discussion inside started at 10 a.m., was only scheduled to go for a maximum of an hour. But as you've seen, we've gone about 2 hours and 28 minutes into that discussion, so much longer now. I don't know how you would read into that. Perhaps they kind of got in the weeds on certain things and certain provisions that needed further discussion. So perhaps that is the reason why it went a little bit longer than expected. But we are waiting for Ken Paxton, Angela Paxton, and others to make a few words here on the steps of the Supreme Court. Hey, we want to thank our friend, our good partner, real quick before we get into all of this. He is a patriot for election integrity. He has been fighting for your vote. He would also be fighting here for your life. Mike Lindell is a big pro-life supporter, and we definitely want to be able to support him as well. So please go on to mypillow.com, mystore.com, put the promo code RSBN at checkout and get up to 66% off your entire order there. And the only way that you can jump ahead of the holiday shopping season, but you can also be supporting a pro-life movement. And Mike Lindell fights for pro-life. He fights for the lives of the unborn. And so today, as we stand on the historical steps of the Supreme Court, I just want to see if you can find it in your heart to go over to mypillow.com, mystore.com, and support the efforts of Mike Lindell there as he fights for election integrity and he fights for the life of the unborn. Programming note, later on tonight we will be at a rally for Glenn Youngkin there. The election of the Commonwealth of Virginia is tomorrow. We'll have live coverage from Glenn Youngkin's campaign headquarters for that as well. This would be the first time since the Biden administration that we have an opportunity to let our voices be heard of what we think the Biden administration is doing so far. So if you live in Virginia and you want to make your voices heard and you want to send a message to not only Washington, but send a message across the country that we will not stand for the radical policies of the Biden administration, and we are not happy with what we're seeing right now. So tomorrow we'll be live from the Glenn Youngkin campaign headquarters, and tonight we'll be for a rally, and it's a parents. It's a parents fight back kind of deal there in Loudoun County. So we'll be there tonight as well. But right now we've got a nice crowd gathered around us as the remarks inside have concluded, and they're getting ready to hear from a couple people here about how we move forward. And of course, this has been a major issue in the public court of opinion. Has been Roe versus Wade, has been the abortion topic. It has been a big discussion. We've said numerous times that if you look across the board at what's important to Americans, and of course the economy is important. We're seeing hyperinflation, with gas prices, food prices, lumber, steel, all of that stuff has gone up. That's a concern. Number two is immigration. Of course, we know what happens with the illegal immigration going into this country. We see the effects of that. But then third is the abortion. It's the right to protect the unborn. And we're glad that you're here today as we get ready to hear a few comments from that. I also want to remind you to go to our app, go download our app off of the Apple or Android store. You can go download our app. It's absolutely free of charge. It gives you the ability to not only watch this broadcast anywhere that you want in the palm of your hand, but also you can go back and look at past archived rallies that we've had, some shows that we have on Right Side, Red, White, and Truth, Laura Trump, Diamond and Silk, and many more right there on our app. So I encourage you right now to go do that. Also, share this broadcast. We just had 2.5 hours of discussion on the Texas Heartbeat act. And now it's time for Ken Paxton and some of the people that behind this to say a few words. So it's important that we get this message out to as many people as we can right now, as this is a key in perhaps reversing the Roe versus Wade judgment that's been in our culture now for quite some time. Very, very controversial ruling as well. So this could be the tipping point to the reversal of that decision. So we're here live. We're glad you're joining us on this beautiful day here in our nation's capital, at the steps of the Supreme Court. We got great sunshine, mild temperatures, and we're glad that you're joining us on this as well. And I want to encourage everybody to follow us on our social media, Right Sides on Twitter, Facebook, Instagram. Go, of course, subscribe to us on YouTube, but go also subscribe to us on Rumble. Rumble has been a phenomenal platform for us in the last couple 6-8 months because of the political environment that we are right now. So I just encourage everyone to go follow us on Rumble and to be able to stay up to date on all of these things and support them as well. Plus, we can't forget about our friends over at Getter. Jason Miller and his staff has produced a phenomenal social media platform tool that is just wonderful to stay up to date at what's going on. Completely safe. Your voices and your opinions can be heard. So go and get Getter on your app store as well. What a phenomenal piece that is. But we're glad you're joining us here. We've been live from about 10:20 local time until about now. We're just waiting for some statements to come out here. We've got a great group of pro-life students in front of us. We talked to several earlier in the show, talking about why they're here, what they stand for, and why this today is so important from a historical factor in our country when it comes to abortion and protecting the life of the unborn, the pro-life movement. And so, and it's good to mention that this is not exactly a political stance. We've seen, we had a speaker earlier that was she was a Democrat, and she was a pro-life Democrat, and she thought it was important that this is not politicized as a left or right issue. This is a human rights issue. And so she was very boisterous about saying that doesn't matter what side of the aisle that you sit on, that the life of the unborn should be protected. So it's nice to mention that this is just not a conservative Republican type based event. This does have people from both sides of the aisle and independents, people that normally have not really gotten involved in politics, and they not necessarily identify as a conservative or Republican, but are a Democrat, liberal. There's very much in the middle. So they're here as well. So it's going to be interesting to see some of the comments, and it'll also be interesting to see tonight and tomorrow, really, with the Commonwealth of Virginia, the gubernatorial race setting, is how many independents and moderate Democrats are able to basically cross over and support Glenn Youngkin and what he's done. I got a report earlier today that the rally just on Saturday night and the rallies earlier today were packed. The attendance was incredible at all these rallies. So he definitely has a ground support here in Virginia. Turning our attention on November 3rd, we will be live from Glendale, Arizona. Carrie Lake for Governor event out there. Election integrity is the topic. Wendy Rogers will be there with some other guest speakers as well. So join us on November 3rd as we're broadcasting live from Glendale, Arizona with Carrie Lake for Governor. I've had several people come up to me today and say, hey, tell me about Carrie Lake. I mean, she's got huge support there in Arizona. Why do you think that is? And here's my opinion. She's for the people. She's just pretty much like we said President Trump was for the people. You take a person, you take an outsider, political outsider, pretty much like Glenn Youngkin, take a political outsider, put him in the realm of politics, and he has the ability to, and she has the ability to reach, I think, that independent, that moderate Democrat, that everyday person, because she comes from a very common sense approach. And so I think that's why you're seeing so much success from both those campaigns, as they come across as very reachable, very obtainable, and very understandable. And so that's why you're seeing some of that. So we'll be out there in Arizona on November the 3rd from Glendale, Arizona. So join us for that as well. And of course, all things Trump, all things the conservative movement, you can also expect us there. Go to our website, rsbnetwork.com, rsbnetwork.com. You'll find a full list of not only scheduled events that we're going to, but also all the articles that we have as well. We have some wonderful writers that on a daily basis continue to push out articles that are close to the conservative cause, and whether it's immigration, taxes, foreign policy, you name it, they are likely writing an article about it. So I just want to encourage everybody to definitely subscribe to that newsletter. So if you go to the website, rspnetwork.com/newsletter, you can subscribe to that as well and get that delivered to your inbox. Put your email in there, then take about a couple minutes, and that's should work out just fine. You promise you we won't spam you. So there we go. If you're not joining us, hey, welcome. We're live here in the steps of the Supreme Court, getting ready to hear a few comments from Texas Attorney General Ken Paxton, Angela Paxton, and many more will weigh in on what they heard over the last 2.5 hours inside the Supreme Court in regards to the Texas Heartbeat Act. This is the first time that abortion really has been on the agenda here, especially now since we have more of a Trump-appointed conservative judges here. We have, I guess you could say the conservative movement would have almost a 6-3 advantage in the Supreme Court. So we'll see how that turns out. Let's listen to it. Let's sing some songs here for a second. Patriotic song as we await for the speakers. I will say that we're on where we're sitting was the pro-life side. Now there's a barricade over to your right that separates more of a pro-choice rally. Now earlier today they were set up. They had speakers. They were out there, very visual, very animated. That has since subsided since the conclusion of the discussion inside. So on this side, the only thing that's set up now is the quote pro-life side of things. So good crowd assembled here. I don't know, we can't really swing the camera around at this point. There's too many cameras next to us, but I would say a very large media presence here today. In terms of covering this event, a lot of people showing up to show their support for either side of this argument. We talked to several people earlier, that a couple of people that you're looking at right now on screen, that gave their reasons why they chose to come here today, and some of the reasons why they chose to be, why they are pro-life. And it's a very personal story. I shared a personal story of mine earlier of why I'm here. So everyone has a story of why this topic resonates so deeply with them, and why it is probably one of the most debated topics in our political realm. You can forget about the foreign policy, economics, immigration, or any climate change or anything like that, but the topic of abortion is definitely there. Hearing a couple cheers from the pro-choice side. I'm not sure if they saw somebody walk out that they recognized. We have some people walking toward us now. I can't get an identification on who they are right now, but we will. Let me see if I can see. Trying to get don't have an identification on these two individuals here. This is probably, we'll start to see some of the people that were inside earlier will walk by and meet the press. As you can see, they have a press set up just to our left. I'm sure they'll deliver a few words there, and perhaps, I don't know if they're scheduled to come down for us or not, but it's at least good to know that some of the people are starting to come out from these hearings. And of course, this has taken place over 2.5 hours, and this is something that was very surprising to a lot of people here, as these initial discussions were only supposed to last for maybe an hour max, and of course that went far longer than they expected it to go, but maybe because of the nature of they did get into some very technical aspects of the Texas Heartbeat Act, so they went deep into this law, and as expected, was debated, and I would imagine that we'll hear a little bit of their opinion of how it went here in a little bit. So I want to remind everybody else as well, you can go to our website. We are greatly viewer supported here. So when you go to our website, we appreciate it. Go rspnetwork.com/donate, rspn.com/donate. As we will continue to cover a lot of these events based around the conservative movement, not just the election, but obviously when you get into topics like abortion, election integrity, immigration, economics. We will continue to bring that news to you. I had a reporter from another network come up to me a little bit earlier and said, "Man, you guys are absolutely everywhere." I say, well, that's because that's what our viewers demand. You guys want us to cover events like this. It's important to you, so if it's important to you, it's important to us, so we appreciate it. Looking at some of the other things in our headlines right now, President Biden is overseas with the climate accord. Okay, walking up now, we have Texas Attorney Ken Paxton walking this way. We'll see if he goes towards us or hits the other media outlet there. I'm not sure which way he's going to go at this point. Looks like he's going around to the barricade over here, going to make his way over to where we are right now. Of course, Attorney General Ken Paxton was very pivotal with really getting this pushed through, not only in Texas law, but getting it onto this platform. So I know, fellow Texans, we can appreciate all of his hard work, not only for Texans, but for America. And that's exactly what Ken Paxton has done throughout his tenure there for the Texas attorney. Make his way over here. Good crowd formed in here behind the podium and in front of the podium, waiting for a few remarks. I'll turn it over to the podium mic as we have Texas Attorney General Ken Paxton. Stand by.
Well, what a great day for Texas and for our system of justice. I am very grateful to represent the state of Texas, and I want to just say, first of all, that I'm very proud of our Solicitor General, Judge Stone. He did an amazing job. I know he's right behind me. And I'm also grateful that I live in a great state like Texas that really does care about life. And as you know, this bill does something that hasn't been done like this in Texas before, which is to recognize that life is protected when the heartbeat is first detected. And I was honored to be in court today representing that viewpoint and representing the laws of the state of Texas that we believe in, that people of our state have elected our representatives to do. And I want you to know that the remedies that the Department of Justice was seeking would be extraordinary. Enjoining a court or clerks of a court from actually allowing people to present their causes of action would be, I think, what they said today, the first time it had been done in U.S. history. And so we're going to continue to fight this fight. And I want to let a few other people say a few words, and then we'll be happy to answer a few questions. I think the first person is Representative Shelby Slawson, who was the author of this bill in the Texas House of Representatives. Shelby, if you'd come up and say a few words. Sorry about that.
Thank you.
Yeah, absolutely.
Thank you so much, General Paxton. It's a pleasure as a woman and a mom and the sponsor in the Texas House of Representatives of the Texas Heartbeat Act to stand here before you today. There is no question that a heartbeat signifies life, and that beating heart in a womb is the life of a human child. When I lost a daughter during pregnancy, the end of her precious life was marked by when her heart stopped beating. The question isn't whether a heartbeat represents life, but the value that we ascribe to it and the sanctity of that life. Numerous other states have enacted laws to protect innocent unborn life, and we are thrilled that the Texas Heartbeat Act is effective and has finally brought about that protection to ensure that once a heartbeat is detected, that little baby's life is protected. Thank you so much.
Thank you, Representative Slawson. I'd also like to invite up, this is by the way, my 35th wedding anniversary. My wife, Angela Paxton, is a senator, and she also was very involved in the passage of this bill and other pieces of legislation related to the pro-life issue. So, Senator Paxton.
Ken said, I have a surprise for our anniversary. I don't know if there's a more beautiful thing to celebrate, though, than life. And I am State Senator Angela Paxton. I am so grateful to be here today as an adopted child myself and a person whose life began under circumstances that often end in an abortion. I am grateful to stand here today, to stand anywhere, any day, because I've gotten my chance to live. I'm thankful to my birth mother, Linda, who made the brave choice to give me life. I'm thankful to Representative Slawson and to Senator Hughes, the authors of this bill, and for the opportunity myself to joint author with them. And I'm thankful for the long-standing leadership on life of our Texas Attorney General and my husband, Ken Paxton. And thrilled to stand with you, Ken, today here on this stage in support of the Texas Heartbeat Act. And you know, to get to the right answer, we have to ask the right questions. And the question before us today is so simple. Shouldn't every human being, every beating heart, have the full protection of the law? You know the answer. Absolutely. And that is the spirit and the letter of the Texas Heartbeat Act. In July on the 2nd of 1776, then General George Washington appealed to his troops with these somber words. He said, "The fate of unborn millions now depends, under God, upon the courage and conduct of this army." And my friends, the fate of unborn millions will now depend, under God, upon the courage and conduct of our Supreme Court. And I want to ask you to join me in praying for them, for their courage, for their conduct. Abortion ends a beating heart. And it is true now. So true. That all of us are among the unborn millions, as are the justices, whose futures were secured by the courage and conduct of General Washington and his army. And to our justices, I say, unborn millions now look to you, and untold millions are now praying for you to uphold the Texas Heartbeat Act. Thank you.
I think this will definitely be a wedding anniversary we won't forget. So I want to introduce a really good friend of mine, somebody that I have a lot of respect for, and somebody that's really made a difference in Texas politics, and certainly as the author of this bill in the Texas Senate. Senator Hughes was an amazing author and somebody that knew what he was doing and has a real commitment to the cause of life, and I'm really grateful for all of his work. And so, Senator Hughes, if you come up here and say a few words, I'd appreciate it.
Thank you. Thank you, Ken. Thank you very much. Equal justice under law. Those words inscribed on this magnificent building behind me and before you. I'm Brian Hughes. I represent the people of East Texas in the Texas Senate, and I'm so honored to be the author of Senate Bill 8, the Texas Heartbeat Law. I'm also a lawyer admitted to practice before this court and on the pleadings in these cases. And like countless Americans before us, we are here seeking justice, seeking that equal justice under law. When does life begin? Once we determine that that little baby growing inside her mother's womb with a heartbeat, once we determine that's a human life worthy of protection, we must grant that protection. And Texas, in passing the Heartbeat Law and increasing funding for the Alternatives to Abortion Act, has shown that we can save the unborn baby's life while we love and respect and support the mother. We can do both. And so we pray, we trust, we believe that our Supreme Court will give equal justice under law and uphold the Texas Heartbeat Act. Thank you. God bless you.
Stay up here. So I also noticed, I don't know, I can't see everybody behind me. And I know we had Senator Campbell here who was a part of this bill, and there's probably some other legislators who I don't see behind me. But anyway, I want to thank them for being a part of this. And I also want to again say that our Solicitor General and his part of our team did an amazing job. We only had about 9 days to prepare for this. Normally you have, several months, and some pretty challenging questions. These people on the Supreme Court are pretty smart, and they ask a lot of really hard questions. And I have to say, I was very impressed with the job that he and his team did, but especially standing up in front of them today and defending this law. I can tell you what, this guy did his job. So again, Judd, thank you very much. And I'm very, very pleased with his work. So thank you. Hey, Donna, would you like to say a quick word? Just say a quick word. And then we'll have questions of the audience.
Thank you, Attorney General of Texas. I'm Senator Donna Campbell, and the Texas Heartbeat Bill leaves a legacy to protect all the future lives, all the future generations. Thank you.
So now I want to open it up for a few questions. I've got my Solicitor General here. I've got the authors of the bill. So if I don't specifically answer your question, I'm happy to have some of them answer questions. I've heard of them. So the focus for me is this case and this case alone. What happens in other states and what their legislators are elected to do are different than what our elected officials are elected to do. And so each state has a responsibility to do what they think is right, and their legislators have a responsibility to represent their constituents' views. And so I'm pleased to represent this state on this particular issue, and we're going to go forward doing that. Okay. I got one more person who's going to speak. Leslie French, my Chief of Staff.
Good morning, everyone. We also wanted to introduce Chelsea Yoakum, who was going to come and give a couple more words.
Hi, I'm Chelsea Yeoman. I'm the Texas State Director with Human Coalition Action, and I helped advocate for SB 8, the Texas Heartbeat Act. And I want to speak to each one of you individually. no matter where you stand on politics, religion, ideology, you name it, there's one beautiful thing we all have in common, one beautiful thing that unites us, and it's that we're all human. Each one of you is created individually with a purpose. You are unique, you are loved, and you matter because you are human. And I think if you let this resonate with your soul, you, like all of the women that our clinics serve, understand the importance of the life in your womb. Human Coalition is a network of clinics serving women seeking abortion every single day with holistic and comprehensive care. And we filed a brief with NIFLA before this court arguing that Texas is uniquely equipped to protect unborn children with heartbeats because Texas uniquely equips their mothers. There's $100 million in the Alternatives to Abortion program, in addition to 8 other state programs, not to mention the private resources ready and able to serve women. And in the last 2 life-saving months in the state of Texas, for the first time in almost 50 years, we've seen a beautiful example of a state that has hope for both the mothers they serve and the unborn children in their wombs. And they're both thriving together in the state of Texas. That's all I wanted to say today. Thank you for being here.
Thank you. Good afternoon. My name is Jessica Anderson. I'm the Executive Director of Heritage Action. And on behalf of the 2 million grassroots activists as part of Heritage across this country and tens of thousands based in Texas, we're here today to stand on behalf of life. We're here today to stand shoulder to shoulder with Texas, as the Attorney General just so beautifully outlined the oral arguments this morning, advocating for life, advocating for the most vulnerable, and arguing that life begins at the heartbeat. We're excited for what Texas means for the entire country, and we do hope and encourage other states to follow the example of this great Lone Star state. For as long as the Texas bill stands, so it will continue to save babies' lives and protect our most vulnerable in the womb. So we're excited to be here. Thank you all for joining us, and I'd like to introduce Mallory with SBA List after me.
Good afternoon, everyone. Thank you so much. On behalf of hundreds of thousands of Susan B. Anthony List pro-life activists across the country, we're here to stand in support of Texas and the Heartbeat Act, not SB 8. If you actually read the legislation, it says it is an act to be known as the Heartbeat Act. So I encourage all of our friends in the press to call this bill by its name. This law has saved as many as 8,000 lives so long as it has been in effect, and it will continue to protect women for the duration. The science is clear at this point. Unborn children are human beings with beating hearts, and this is why I think we're not hearing people call it what it is, the Heartbeat Act. For half a century, this Supreme Court here has shackled states like Texas to a radical policy of abortion on demand up until the moment of birth. The United States, we're just one of a small handful of countries, including China and North Korea, that allow abortions beyond the point that babies feel pain and all the way up into the moment of birth. Baby Joe doesn't like that. And you know what? A majority of Americans agree that it is too extreme. So we're praying for justice today, and just weeks from now, when the Supreme Court hears the Dobbs late abortion case, this court is going to have an opportunity to correct its past overreach and allow states like Mississippi and Texas, and indeed all states across the nation, to pass laws that reflect the values of the people that live there and to protect life. And we look forward to that day. Thank you.
Hello, everyone. I'm Penny Nance. I'm the CEO and president of Concerned Women for America. We have 500,000 members or more around this country. We have Young Women for America chapters, and we have thousands of members in the state of Texas who joyfully work to pass this bill. And so we're here today representing them, and we're grateful that you're all here. Psalm 139 said, "You created me in my inmost being. You knit me together in my mother's womb. I praise you because I am fearfully and wonderfully made." We stand here today in recognition of all those babies, those 64 million babies who died at the hand of Roe v. Wade. And we recognize that states are stepping forward and saying, no, no more. We need to stand forth and limit abortion and be responsive to the women in our state. And so we're grateful for the Texas leaders that were here, and we're praying that the court makes the right decision. Thank you.
My name is Mary Zock. I'm the director of the Center for Human Dignity for Family Research Council. And this is my little boy, Joe. Joe's 3.5 months old today. And in 4 countries in this world, Joe could have been aborted up to the moment of his birth 3.5 months ago. And he's crying about that. Sadly, one of those countries is the land of the free, the United States. It's very sad. And Texas was not okay with that. Texas found a way to protect little babies in the womb up until the moment that they're born. Little babies like Joe. Texas said the abortion industry will no longer prey upon our women and children. And thank goodness, because the world could use a lot more Texas.
I'm Carol Tobias, president of National Right to Life, an organization that has affiliate in each of the 50 states with chapters all over the country. We want to thank Texas for their hard work in putting forward a very creative idea to protect unborn children. And they're saving lives, which is amazing, and we're very grateful for what they have done. I want to remind everyone, I mean, you already know it, and I'd like to remind the Supreme Court Justice that the 10th Amendment allows states to set their own policy to determine what they want to happen in their laws. The Constitution does not protect abortion. It does not mention abortion. So I think the states need to be very forceful in pushing forward that, yes, we are going to protect those babies. And I'm looking forward to seeing what the next couple of years does around this country, because I think we are going to see a sea change in the laws that do take place. So God bless you, and thank you for being here.
Hello, my name is Elizabeth Nogueras with Students for Life of America and Students for Life Action. Students for Life has more than 1,250 groups across all 50 states. One being the great state of Texas, where an innovative idea to protect life came to law and came to fruition, and it's what draws us all here today. The Constitution does not have abortion rights written between the lines in invisible ink by 7 men in 1973. Texas has empowered their citizens, and the pro-life generation supports Texas's efforts to find the way to stop the violence of abortion in an innovative and creative way. When Roe is returned back to the states, we're going to see a lot of innovation in how these laws are written. And the voters are ready for that. At Students for Life, our own original polling of millennials and Gen Z says that 7 out of 10 want to vote on the issue of abortion, and more than 7 out of 10 want limits on abortion. Despite the media's spin that people don't support heartbeat legislation, we also found that support for protecting young life was there. On a battlefield and in an emergency room, a heartbeat is a universal sign of life. Leading people to rush to offer life-saving care. Only when it comes down to abortion do we ignore what we all know. A human with a heartbeat is a life. It is a life worth saving, it is a life worth protecting, and it is a life worth supporting. This is an exciting year for the pro-life generation. Students for Life was here when Kentucky's Attorney General was right here in this very court being asked to protect life in law. We stand here today with Texas, and we will stand here on December 1st when Dobbs v. Jackson is heard. 1/4 of my generation is gone to the atrocity of abortion. It is time that we protect life in law. Thank you.
All right, thanks for joining us. We have been live since around 10:20 here, local time here at the steps of the Supreme Court, as the details and some of the arguments were made earlier at the Supreme Court. Attorney General Ken Paxton joined us as well, had a few remarks here to talk about what he heard and what can be done moving forward. We want to invite everybody right now to log on to our website, rsbnetwork.com, and be able to subscribe to our newsletter. It's more important now than ever that we all stay informed of what's going on, and that is certainly one important tool that will help you keep up with all the things that we're doing in terms of political realm, in terms of the abortion discussion, in terms of immigration as well. So go to our website, rsbnetwork.com/newsletter. Also want to end this broadcast today. Today's November 1st. It is a big day here in the Supreme Court. It's a big day in the state of Texas. It's a big day in this country. Mike Lindell is a patriot. He is a patriot that has been fighting for election integrity ever since post-November 3. He would be here today. He is, without a doubt, fighting for pro-life movement. So it's hope today that you can help him. Go to his website, mypillow.com, mystore.com, and use the promo code RSBN at checkout and get up to 66% off your entire order. I say that to you now because in such an important topic like abortion in this country, and it's such a heated debate, and it is really doing, we're standing up for God here. We're standing up for life. We're standing up for the unborn. We're standing up for the woman's health, that you can do that and support Mike Lindell and what he does over at MyPillow. He is an advocate of pro-life, and I just want to encourage everybody right now to go maybe jump ahead of the supply chain issue, jump ahead of the Christmas season, and shop away, buy some of those quality Giza sheets, towels, pillows, all the dog beds, slippers, you name it. You might have saw the fact that we were live there just a few days ago from the MyPillow factory. So I just encourage you to fight back with your wallet, fight back with your heart, fight back and support pro-life cause. Go to mypillow.com, mystore.com. Programming note, later tonight we'll be live at Glenn Youngkin's rally there in Loudoun County. It's kind of a parents' fight back type situation there. He's flying all over the state today, as tomorrow is election day in the Commonwealth of Virginia. We'll be there live at his headquarters tomorrow for full election coverage from the Glenn Youngkin headquarters. So join us tomorrow, join us tonight, and you can always join us via the app. Go download the app onto the Apple or Android store, free of charge. You can keep up with everything that we do. You can follow us on social media as well, across on Twitter, Facebook, Instagram, and of course subscribe to us on YouTube and Rumble. You can follow me on social media as well at Brian Glenn TV across the board on Twitter, Facebook, and Instagram. Until next time, goodbye. God bless from the Supreme Court here in Washington, D.C.